I'm wondering if anybody on the board knows of a conflict as we sit here.
No conflict.
Well, how about that? Do you think we can all agree on that, next two dates, at least tentatively? Looks like a consensus. I see a consensus.
Yes.
Great. I always skip the 4th of July week because I think particularly it's falling on a Monday this year.
Yeah, okay. All right, that's good news. All right, so the first, we have 1, 2, 3, 6 continued hearings. Do we? 6 continued hearings and 3 new hearings. The first continued hearing is the 62 Rust Way. We have a draft decision of this, but we have left it open in the event that there is new information to be submitted. Do we know if John Cavanaugh is present, if he has any?
He is here. I'll promote him to panelist and see.
Good evening, members of the board.
Yep.
John Cavanaugh here on behalf of the Nortons from Cavanaugh Consulting in Norwell, Massachusetts, and there is no new information regarding this hearing. I would also ask, if possible, at the request of the board, I need to actually get on to another town within 5 minutes, and I was wondering if I could also state for 51 Gammons Road that there is also no new information for that property.
Okay, well, I would make a motion, 2 motions. The first of which is to close the hearing on 62 Rust Way. Do I have a second?
Second.
Seconds, and all in favor? Woody Chidick, aye.
Lee Darcey.
Charles Higginson, aye.
Matt Watkins, aye.
Michael Dickey, aye.
Okay, so that's closed. The second motion is to close the hearing on where were we?
He's on 51 Gammon, so
51 Gammons, sorry, okay. 51 Gammons Road, the dock. So the motion's been made. Do I have a second?
Second.
Okay, moved and seconded. Sorry, Cindy, what? You're muted.
I only have one question. I apologize, but I can't get the agenda up with the Zoom meeting at the moment. Is the Gammons Road hearing noticed for a particular time?
it's a continued hearing, so it doesn't matter.
Okay. That was my only question.
Thank you. All right, so you have you have a motion and a second. We just need a roll call on 51 Gammons.
Okay, Woody Chidick, aye.
Lee Darcey.
Charles Higginson, aye.
Matt Watkins, aye.
Michael Dickey, aye.
Okay.
Thank you very much for your consideration. I appreciate it.
All right,
Not a
and
problem.
David is here. I'm going to promote him to a panelist.
Okay.
All right.
Yep. Okay, so David Morris has joined us just in time because we will now move to the second agenda item, but third that we're dealing with tonight, and that is 147 South Main Street. Special permit request plural. So I would, I know we've had a flurry of information, some as late as this afternoon. But at any rate, let me turn it over to the applicant and Adam Brodsky. And why don't you take us forward from where we were a month ago? And
I am stepping off.
Thank you, Mr. Chidick. Good evening, everyone. We should also have, there's Mr. Schiavo, thank you, as well as Greg Morse. And if you could please promote Greg, I would appreciate it.
All set. I thought I had done so. Sorry.
I may not be seeing him on my computer. Thank you and good evening. We last met on May 4th and we had 2 deliverables. First, the board asked for additional information evidencing the non-conforming parking at the front of the property. And we provided to you 17 affidavits from Cohasset residents, attesting to the non-conforming parking on that portion of the property. You have testimony of numerous people who observed vehicles numbering from 7 to 11 over a period of many years. And we also provided to you 6 additional aerial photographs to supplement the other photographs that depicted the non-conforming parking conditions, at the property. And second, you asked for additional information regarding the height of the former building, and Mr. Scavo provided to you some additional information confirming his prior testimony that the former building was approximately 40 feet tall. I have to candidly say that I'm not sure of the relevance of the height of the former building, since the proposed building is lower and conforms, but we tried our best to provide that information to you. I did receive from Mr. Chittick a memo this afternoon, which I've had only a quick amount of time to review. One of the issues he raises has to do with information regarding the prior building, and I'll address that at the appropriate time. And lastly, we provided to the board today copies of the revised architectural plans. When we were last in front of the planning board raised an issue regarding handicap accessibility. And so minor changes were made to the interior of the building to accommodate ADA access. The footprint of the building has not changed. And I believe that the only exterior change is the addition of a small dormer off the second floor. So the plans were simply changed to accommodate a stair lift on the interior of the building, which resulted in one unit being located on the third floor, and again, a small dormer for a bathroom.
And I don't think we've had a chance to, most of us haven't had a chance to see that because it came in mini size. But you just said something, a third unit is now on the third floor?
No, sir, a third bedroom. So one of the bedrooms and one of the units was moved from the second floor to essentially the attic space to accommodate the stair lift. So that was the change. And we did provide paper copies to the board today also, but we did submit electronic copies. The point I was making was that it doesn't change the footprint of the building, which is really the subject of this hearing. Minor interior architectural changes to accommodate the request by the planning board. So as I mentioned, I'm happy to speak at the appropriate time to Mr. Chittick's memo, but I'd just like to remind the board that we are simply running out of time for this project. We have a limited amount of time to permit the proposed project before time runs out.
Why is that, Adam?
That's because he has a finite period of time to reconstruct the building as a matter of right. So,
right, but once you're before this board and this board continues a hearing, aren't you protected?
I don't believe so.
You're not delaying the, you're not in danger. You're not causing any delay in that 3-year or 2-year abandonment period. It's this board seeking more information. I couldn't imagine that we would have the authority to continue a hearing and then invalidate your entire application.
I'll defer to the board on that. We've been operating under the assumption that we have a finite amount of time in which to reconstruct the existing building. And as the board knows, we would much prefer to build something that's less impactful to the neighborhood than what existed previously. And so I just wanted to remind the board, at least of those time constraints. I'm happy to consult with town council regarding whether the filing of this application stays that particular time period. I was under the impression that it did not, and those are some of our concerns. But
okay, why don't we deal with that offline? I think it may be.
Of course. So the only point I wanted to make is that we're very concerned with time, and I wanted to remind the board of that. So again, at the appropriate time, I can do my best to respond to Mr. Chittick's memo to the extent I can. I have not had a great deal of time to digest it. I could make a few points if that would be helpful, or I'm happy to address those issues one by one if the board wants to discuss them at the appropriate time.
Well, let me ask the board what its desire is. You have questions of the applicant you'd like to put on the table now, and then,
I thought that your memo provided a pretty good framework for most of the questions that I had.
Yeah, I think
And I
it's a
think-
good starting point, maybe if.
They all need to be addressed.
Yeah.
okay. Well, why don't we take it, Adam, that way?
Yes, sir. So again, I've only had this for a short period of time.
Yeah, I apologize, but
No, sir. I mean, we're all working the best we can. The first is the concern that we have not provided sufficient information regarding the dimensions of the prior structure. We do not have any plans that show the prior structure. We did accurately depict the footprint of the structure on the existing conditions plan. So you do know with accuracy where the footprint of that structure is, but we don't have any plans showing the construction of that. I would remind the board that we don't have access to town hall under COVID conditions. Circumstances have just changed. And so, we've not been in a position to rummage through the basement looking for things. We certainly can try and do that. I'm not holding out hope that we will find construction plans.
well, why don't we see how the conversation unfolds and the questions unfold tonight? If we feel that we need it to see, because you're extending, let's say, a nonconformity or making that argument, you will have to prepare those. You will have
So
to have a registered actor, but it may not be necessary. So let's see where the questioning goes.
That's correct, because it's not relevant because we are providing a conforming building. The non-conforming, essentially, use, and I'll talk about uses in a moment, it's really having to do with parking. And we've provided to you whatever documentation we've been able to reasonably acquire with respect to the non-conforming parking, including aerial photographs over periods of time, as well as eyewitness testimony. So I don't think that the actual dimensions of the building are necessarily relevant, with one exception, which is that you did ask about building height, and you properly reminded us that a building height is measured from the pre-construction grade. Obviously, the architectural plans show the building height at 33 feet. We actually answered this question for the planning board, and Greg can speak to this because the site is being filled modestly, but he can tell you what the building height will be, taking into consideration the pre-construction grade. Greg, can you talk to that briefly, please? And you're muted, Greg.
For the record, Gregory Morse, registered engineer. The architectural plans put together by Dick Rockwood call out a building height located to the midpoint of the roof. The midpoint of the roof is where you would measure building height in this scenario. It's coming in at 23 foot, 8.5 inches. And that is measured to the pre-construction grade at the site. The zoning bylaw allows a maximum building height of 35 feet. We're coming in at 23 foot, 8.5 inches.
You aren't coming in at 23.5 feet. You've made an error there. It has to be the midpoint of the highest roof.
Okay. Even with the midpoint of the highest roof, if you look at that, that's shown on page A2.2 of the architecturals.
Yeah.
If you look at that, that's the highest roof. That's a dormer bump out essentially to accommodate the stairwell. Even if you do that, we're coming in at a total height of 33 feet to the maximum of that.
Why don't you give us the number of the or numbers of the drawing that you're referencing?
Sure, I can put a share screen up and show you the architectural
Okay.
plans. So on the architectural plans here, if we go to page A2.2,
Okay.
down here on the bottom right, this here would be the primary roof, but the highest dormer you can see is right here where the cursor is. Okay, that highest point there, if you go over, if you measure from that ridge point here down to what the existing grade was, the existing grade at the site averages at 7.5. It puts that ridge point, that mid ridge point right here, it puts that at elevation 33 feet.
Right, and the bylaw is 35 feet.
Correct. So it's 2 feet below maximum to that midpoint right there of that dormer.
You may not need to measure to the dormer. It may be to the midpoint of the highest roof, though.
So the highest roof would be this roof line right here. And that's what I gave you in the first case, which if you look at the first page, this is the facade of the front of the building. This is the highest roof peak. And if you, this is the facade of the front building. This is the highest roof peak here. This here depicts the average of that roof. And if you zoom in on that, you will.
I would have chosen the left side elevation.
Okay, well, even.
But whatever it is, it's
even,
33 feet plus or minus, you're saying.
Even so, from all sides, it complies with your requirement.
And that's, as Adam was talking, that is to the pre-construction grade or to the any grade that's been had additional fill?
That's the pre-construction grade. And the pre-construction grades are based off a survey that my office performed. I can give you an exact date here.
That's all right.
November of 2020.
Okay.
I can leave this up or I can stop the share.
Okay, you're saying this hasn't really changed. The exterior has not changed, Adam, in terms of height.
Yes, sir.
Since the early made drawings that we were given.
Yes, sir.
Okay. Board, do you want to, what comments do you may want to make on whether, it's going to be a little hard, I think, initially to determine whether we need to see renderings of the prior structure or not. I mean, at one level, it may not be necessary, but depends on the kind of relief they're going to see. Anybody?
No, I'm pretty satisfied about the comparable footprint, even though it's in a different location, because I think that improving it from a non-conforming location to a conforming location is a good thing. I'm much more concerned at this point about some of the parking questions and the use questions, frankly. So I'm happy to move on from them.
Okay. Matt, any contrary points of view or additional you'd like there?
No, I'm all set. Thank you.
Charlie?
No comment.
Okay. I don't see Mike and Lee, but I assume you'll say something if you wish to
I think Lee's recused.
on this
No.
one.
I have no questions, Woody.
Okay, thanks, Mike. Okay. All right, well, proceed, Adam.
Oh, thank you, Mr. Chittick. Similarly, with respect to volume, we're not seeking relief for a non-conforming structure. So I don't think that the issue of volume is relevant. And let me sort of get to the heart of the issue. We requested relief under both sections 8.7 and 8.8 of the zoning bylaw to deal with both the extension of non-conforming use and the change of use. With respect to the extension of non-conforming use, there were two aspects of that. One, you will recall that there was a residential use on the second floor of the original building. There were two residential units. The new building has the same residential footprint as the old building, but we're proposing 3 units instead of 2. That's why we thought it was a reasonable request under 8.7 to extend that aspect of the non-conforming use. Again, dimensionally the same. We simply broke up the space into 3 units rather than 2 units, which we thought was a appropriate use of 8.7. And second, we're asking for the extension of the non-conforming parking use, and we're happy to talk about that in more detail later. With respect to the change in the commercial use, that was proposed to be a change in use under section 8.8, which I noticed was not addressed in your memo, but that's a separate request for relief. And we believe that the change from an auto body repair shop to commercial office / retail is substantially less detrimental to the neighborhood than the prior use. And thought
Adam, that's not the test under 8.8. Why don't you read us 8.8, section 8.8? It's not a long, it's only 4 lines.
the special permit granting authority may authorize by special permit a non-conforming use of a building, structure, or land to be changed to a specific use not substantially different in character or in its effect on the vicinity, provided that it finds that such change shall not be substantially more detrimental than the existing non-conforming use to the neighborhood.
Okay, so the argument is that you're making is that the change, the specific use is not substantially different.
Correct, and provided you make the finding that it's not substantially detrimental.
Okay, so let's say it's not substantially detrimental. How do you argue that an auto body shop and a series of professional offices, or whatever you want to call them, mixed use facility, are not very different uses? They appear in different pages, in fact, on our table of use, section 4.
They're both commercial uses that are open to the public, as opposed to a residential use, or as opposed to an industrial use, or as opposed to a public recreational facility. They're similar in kind and similar in use. The similar number of patrons are going to use these businesses. In fact, I'd suggest that if those are offices, that the intensity of use will be a lot less than an auto body repair shop.
Even though these uses are listed as no under the table of use regulations.
Correct. I mean, this is very specific.
Prohibited.
We have existing non-conforming uses, which we're proposing to change to other non-conforming uses.
So it could be changed to a storage yard. It could be changed to a let's see, resident outdoor motion picture establishment there. We could put that there.
Yes, sir. Provided
Wind energy conversion facility could go there.
It's provided it's not substantially more detrimental to the neighborhood than the existing use. That's correct, Mr. Chair.
If it's similar in character. It's not just not substantially more detrimental. It's also not substantially different in character.
That's correct.
Is part of the test. So I don't think you can say that any change of use that's not, it's not industrial or something like that is okay. I don't think that that fits within that restriction.
Many of these uses are allowed in the table. Many of the uses require special permits, and a number are absolutely prohibited. You couldn't say that going from something that's approved to an unapproved use is substantially similar. Well, you can say it, but I don't know what the rationale is.
So, but Mr. Chittick, this provision deals with non-conforming uses being converted to other non-conforming uses. So I agree entirely with Mr. McMorris's articulation of the standard, which is why I said that, you know, their similar commercial uses would be different than if it was, for example, an industrial facility or an energy facility or something like that. So I agree that that is the test, and that these are similar in character and not substantially more detrimental than what existed previously.
Cindy, what?
I do want to speak to your point with respect to the residential use being illegal, and you cite to that 2004 case, which I have yet to read, but I'll be corrected by town council. I believe that 40A Section 6 was amended in 2016 to actually address this situation. So I believe it was amended to allow for an illegal use, which is in existence for more than 10 years, for which there's been no challenge filed, is then deemed to be a lawfully non-conforming use subject to the ability to be addressed under Section 6. So I have not read that 2004 case. I don't know whether that case survives the change in the statute. So again, I can't speak to whether these uses.
Well, you can provide us with the change. I will say that I came across that one first in Bobrowski's 2018 edition of his handbook, and he cites this as the prevailing. It's an appeals court decision, and that he cites this as the fundamental rule about uses are not grandfathered.
So again, all I can tell you, and I'll be
All right,
correct.
but if you have other law, fine. You can submit it to us.
Well,
for the next hearing.
it's the statute which was amended by the chapter 184 of the Acts of 2016, which actually amended chapter 48, section 6. That actually, I don't know. I'm not conceding that apartment use was illegal. That was simply something that you were told by the neighbors. I don't have any additional information regarding it. It's been in existence and public knowledge for decades, I'm told.
What has been?
The fact that there was a residential use on the second floor. Maybe decades is an exaggeration, but Mr. Chavo can answer that question.
Well, that would certainly be news to the assessors who are unaware of it as recently as last year. And they have never been aware of that. It's never been permitted. Check with the Board of Health. It's never been authorized in any sort of building permit or anything else.
Just if I can interject here, I think the time element on a lot of this stuff is important. So please try not to exaggerate, particularly with regard to time.
Thank you, Mr. McMorris. I caught myself and corrected myself. Mr. Chavo, how long is if I can ask Mr. Chavo, how long has that residential use been on the second floor, or was on the second floor of the building, please?
It's been there for the entire 41 years that I've owned the building. I lived there for over 15 years myself, and they all had separate addresses. 147 was for the commercial, there's 147A and 147B. I lived in the bigger of the two apartments with a girlfriend and actually raised my niece there as well. So I lived there from the early 80s right up into the 90s and way into the 90s. You can look my address up. I even had license to bear arms through the Cohasset Police Department and so forth and so on. So I lived there quite a while myself. So that's always been legal apartments. I don't know where they're getting this information from.
Well, it's town information.
And as far as the assessor, as of last year, the building's been burned down for 2, so I'm a little confused on that.
All right, so
but-
I don't know, 2019, it was his 2020 assessors, but it's not important. Going back at least to 99, you can do this online.
Right,
That address is listed as having no bedrooms, no bathrooms.
that is not true.
Well, it may not be true in your estimation, but it is, but that's what the assessor's record shows.
Yeah, and you know, obviously, the use of the apartments went back with the prior owner living there and renting them out as well as Sylvia's. So that goes back to the 50s.
And I just think we need some proof that that these were legal apartments.
So
But
again,
Adam, you can do that between now and the next hearing. We don't need to bog down now. But you have to come up with some, you know, substantial proof, substantive proof that these were apartments that were allowed, authorized in some fashion.
I respectfully disagree with Chick. I mean, as I mentioned, the statute does not require that. So if you had an illegal use that existed for more than 10 years, and I can read the statutory change if you want, and no notice of an action, suit, or proceeding as to an alleged violation of this chapter or of an ordinance or a bylaw adopted in this chapter has been recorded in the Registry of Deeds within the period of 10 years from the date the structures were erected, then the structures shall be deemed for zoning purposes to be legally non-conforming structures subject to Section 6 and any local ordinance or bylaws relating to non-conforming structures.
Great. Now your instructions, tell me about the uses. That's different.
Yep. I'm going to have to look at that, Mr. Chittick.
Okay.
So going on with respect to parking, again, we did provide the best information that we could with respect to the non-conforming conditions. I actually respectfully disagree with your recitation of what happened in connection with the 1991 variance.
Okay.
And I'm not impugning the reputation of Myrna Husiger or suggesting that what was done was incorrect. But if you actually parse out what happened, it's confusing at best. From what I can gather from review of all of the documents, that an enforcement letter was issued regarding the parking of more than one unregistered vehicle on the property, and the use of one of the lots, the residential lot, lot 90, for access from Spring Street to get to the back of the garage. So there was a question regarding the parking of more than one unregistered vehicle and access over lot 90. That enforcement letter was appealed to the Zoning Board of Appeals. The Zoning Board of Appeals denied the appeal, found that actually the Schiavo proved that the grandfathered use of the property and access, but could not prove the grandfathered use of, I guess it was only lot 90, which is the rear lot to store cars. That was appealed to the Superior Court. He remanded back to the ZBA. The ZBA, when presented with additional information, actually reversed its denial, finding that Schiavo had proven that up to 24 cars were stored on lot 90 prior to 1955. And so it was actually a finding which reversed its enforcement decision, but also granted a variance. And I have no idea why they granted a variance. In fact, I think there was some question as to the original application of filing for a fence variance. But the point of all of that in 1991 is it established the non-conforming business use and the non-conforming parking, including both the front and the rear portions of the property. Again, to the extent that there was a variance granted, it's really unclear. That variance related to the rear lot, which is lot 90. I didn't find that variance to be relevant at all, except actually confirm the non-conforming business use of the property as of 1991 and the non-conforming parking as to 1991.
Anybody else want to jump in here?
Yeah. Whether there was a, permissible use by variance or special permit or whatever of 10 cars or 20 cars or 90 cars, why do the other requirements of the bylaw not apply?
Correct, because the prior non-conforming parking was in the front yard setback, was in the side yard setback.
Where
And
does it state that, Adam? Where does it state that?
It doesn't. That's why I've never relied upon that 1991 decision, because I don't think it's relevant. What's relevant is the testimony that we provide to you regarding the prior non-conforming parking conditions. That's my point entirely, Mr. Chittick, is that 1991 variance really doesn't lend itself, or doesn't really come into play in this. It's just an odd, unusual decision in the history of this particular site. Again, the number of parking spaces were provided. Again, is part of the non-conforming that we're asking for relief from. So.
And the ask, Adam, I guess simply put, is for the board to try to rely on the affidavits for that, as far as, I mean, the kind of the proof ends there, in your opinion?
It's the best evidence we have. This is not a site which had plans which showed number of parking spaces that we can measure and lay out and point to. This is something, I believe, of the Wild West of parking. Cars are parked everywhere, all over the lot, at various times, within the yard setbacks, within the side yard setbacks. We're trying to actually clean up the site, and literally with respect to parking. So now what we're proposing are actually dedicated parking spaces. But we do need relief in order to be able to construct the project.
You know, it could be argued, though, if you turn it a little bit, that the variance that the board was remanded and granted after a remand simply dealt with the number of cars in the lot, most of which, the vast majority of which, were stored in the rear. We know that.
Yes, sir.
There were very little parking in front, and the board felt it was unnecessary to specify that you ought to comply with this bylaw and that bylaw, blah, 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 because the assumption was that parking would follow the requirements of Section 7.
I can't make any of those assumptions. None of that's reflected in any of those documents. The issue was the parking of.
The assumption is always, if a decision is silent, the assumption is always that what's left is going to comply with the bylaw.
I don't think you can make that assumption here, because we've shown you photographs, even going back to that time period, that shows the parking was non-conforming. I don't think it was the subject matter of that particular enforcement matter. And so I don't think you could broadly assume that because the enforcement matter didn't address other non-conforming issues, that everything that existed as of 1991 was conforming. I don't see how.
But you're arguing that because it didn't address it, it gave a waiver, if you will, a variance to all types of parking in the front, the side, wherever?
No, sir. All I'm saying is that the site has historically been used for parking in the front, which didn't conform to the zoning bylaws, which makes it non-conforming. And we're simply asking to extend that non-conformity to accommodate more orderly parking for this project.
Yeah.
Mr. Scavo has his hand up. It's not my position to recognize him.
Go ahead.
Okay. I can explain the parking in the front very easily. The parking in the front on South Main Street, that's where you would enter the building during the normal course of coming in to get your vehicle repaired. So you pull in on South Main Street. At any one time, I've ran that business for multiple years. You don't pull in the back of CVS or any other business in the town that you attend. Am I correct? You pull into the front of the building, which was on South Main Street. So at any one time or any time there was at least a dozen cars parked out there, you would go in. There was a foreman's office to the left and my secretary's office to the right, where you would either go in and pay your bill, or see the secretary, or go to the left side of the front of the building where the 3 bays are on South Main Street and drop your vehicle off. And that included boats, some, small backhoes, so forth, whatever you needed to be repaired came in usually on South Main Street, unless it was a bigger vehicle or something to be towed in was brought into the rail lot. That's the way business is conducted. You go to the front of the building where the offices are. That's why there was so much parking in the front of the building. So it's that, simple. So there was always cars parked out front there. Then of course, Sunday morning during church, you couldn't even move in that parking lot. There was probably 30 cars parked there. Or at nighttime when, there's a funeral or, something to that effect. So there was always way more than 7 to 8 cars parked out front there in the 41 years that I know of the property. It's that simple. You pull into the front of a business to do the business.
Well, we'll have some interesting, I think, submissions of evidence to look at. We have no photographic evidence of 7 or 8 cars in front. We have a series of almost 20 years of photographs which your side submitted, showing anywhere from 2 to 4 cars,
Right.
quite possibly there, but never more. And we have 3 different abutters testifying more or less to that fact. So we have maybe some conflicting evidence here that we'll have to sift through.
Yeah, you have an affidavit from Robert Ross, who was born in the neighborhood and actually worked for me as a body man. I taught him the trade, which now he's up on the Situate collision on, 3A. So there's supporting evidence from a butter there. Then you'll also look at the affidavits from some fairly elderly people that are residents in Cohasset that date back to the 50s. And I can refer to their names if you would, like.
Well, they're in your affidavits.
Right, there's 17 of them there. You asked for 6 or 7. I wrote the number down at one of the prior meetings, and I went above and beyond that. And I got various ages on purpose to show it's happened from way back when to before the fire. Most of the customers continued from one business person to the other because they're used to going to the location. As long as they're treated well, they will return to where you normally go. That's a simple form of
Well,
business.
many of these couldn't have been customers at the start, at least. There was a 6-year-old girl.
Well, who would go there with?
She was driving the car.
Well, no, but they would go with their mother and father. I don't think at 6 years old they were left alone and they would see cars there.
Right.
That's, fairly simple.
We
Plus
can
they
evaluate the
right, and they would be driving by South Main Street. It's a main road in town outside of Route 3A. So you would see things as you look over, slow down for people to pull out of the church. So you would see the cars there constantly. In support of the affidavits.
Right. Charlie, do you have a point of view in this? Charlie, you with us?
Yes, I'm with you. But I haven't had a chance to look at all of these things that came in
Yeah, I
late.
know. It came in pretty late. Yeah, I know. We can certainly have a month to go through it. Matt?
No, I think we've talked about it a bit. I was looking at some different map programs today to try to determine what I could or couldn't see there. I'm sure that there are times that there were and times that there weren't that amount of parking from what I could come up with on my own research,
Mike, where are you in this? You want to move on or deal with Parkinson?
Seems to me to be a disputed fact. And I think there's apparently different claims that kind of are in conflict. So I guess our role is to try and sift through and separate the wheat from the chaff, huh?
I think so. Yes, Jen, you had your finger up?
I just wanted to mention that if Patrick Brennan from Amory Engineering is here for a bit, I don't know how long, and I don't know how long we have other hearings to get to, but he did our peer review for the planning board as well as the zoning board, mostly focusing on the site. So if the board had any questions or anyone, I just wanted to mention that he is here. I know David had some, Mr. McMorris had some concerns about the water flow, and I didn't know where you are in the list, but I didn't want to lose him because I know he has a couple other meetings.
Okay, I don't know what, does the board have questions of Mr. Brennan?
I think most of my questions about the stormwater issues have been pretty well addressed, I think, in the Amory report. Did they look at all at the parking issues?
They did not.
Okay.
So I just thought I wanted to invite Mr. Brennan to come in the event because you had mentioned and supply the reports if you had any questions. If you don't, then we should let him go. But I just wanted you to have the opportunity.
Yeah. I'm all set, I think.
Okay.
Yeah, I'm just double checking the memo. I know that there were 3 memos that were provided, and I just was re-looking at them to see if there was I guess Patrick, I guess it would be fair to say that there were 11 items that were bulleted out, and due to some back and forth with yourself and Morse Engineering, the highlights seem to be that we were satisfied with essentially 11 of the 12, and just have made a recommendation that there be some likely some hauling of snow off site to satisfy number 10, but otherwise with the drainage considerations and means and methods that were proposed, you were generally satisfied?
That's correct.
Okay. All right. Yeah, no, I thought that they were good questions, but I think by the time I got to the 3rd memo, I realized that you guys had come to terms with the majority of it. So I don't have any further questions.
Okay, I guess anybody else on the board have questions of Mr. Brennan? Okay, thanks very much for coming.
Mr. Chair, there's one last issue that you raised in your memo that I'd like to speak to briefly.
Sure.
Which has to do with the question as to whether the boards can require a site assessment to look for oil or hazardous materials on the site. And all I would say is that I do not see that anywhere, that ability within Article 14 of the zoning bylaws. The zoning bylaws regulate uses within the water resource district. Certain uses are prohibited in order to protect water quality. We require
You're talking about 4C? There's
I'm talking about generally about 14.4.
Yeah, I mean 14.4.C, and then the 6 conditions under that.
Well, correct. But the only thing that we had triggered was impervious. We no longer need that special permit because we now conform to your impervious coverage. So we no longer need a special permit for within the water resource protection district.
Because you're down to 30%?
That's correct. The point being is I do not believe that anywhere within the zoning bylaw it gives the board a jurisdiction to require a private property owner to conduct a site assessment to look for oil or hazardous material on a property.
Well, my comment in my email was really that this is more of a planning board or conservation commission issue as opposed to zoning issue.
Well, thank you.
So I think we agree with that.
Thank you. Then I misunderstood. Again, I read your memo very quickly to try and digest everything.
I wouldn't argue the point.
And I made the same points to both the planning board and to the Conservation Commission. Again, during construction, if we encounter any oil or hazardous material on that site that requires that it be reported to the Department of Environmental Protection, we're going to do that. And if the contractor, the owner fails to do that, that's a violation of law. It's as simple as that.
Okay,
So again, that was my best attempt to respond to the key points within the memo that I got late this afternoon. And again, we're happy to answer any further questions the board may have, and happy to try and provide additional information if it exists to help the board reach a decision. I'm going to read that 2014 case. I'll read Mr. Bobrowski's treatise, and I'll try my best to answer that particular concern. Again, we haven't conceded that that use is illegal. All we've conceded is that it's non-conforming.
Adam, can I ask a question and follow up to one of the items in Woody's memo? I understand we have all the affidavits, we have all these photos, we have things that show fairly continuous violations of the setbacks. Unless there's proof that those violations of the setbacks occurred all the way back before the zoning bylaw, then all they are is evidence of continuous violations of the setbacks, which don't give you any grandfathering rights. I understand that the issue you cited with the 10-year period, but that doesn't have to do with violations of setbacks. That has to do with the use in structures that are illegal. So I'm not sure that all the information that you provided us so far about where cars were parked and when and all that means anything, unless you can show us that before 1955, things were parked in the setbacks regularly. Am I technically wrong on that?
I'd have to go back and examine the bylaw changes for those particular parking requirements. So I can't answer your question because I don't know, for example, when the five foot sideline parking setback was enacted and whether it's been changed over time. Okay. I don't know when the front yard setback was enacted. I can go through that exercise and provide that to you. One of the interesting things about parking, I mean, is parking a dimensional issue? Is a use issue? It's treated as one or both or either at various times, and so we struggle. I mean, when we began this project, I mean, I did consult with the building commissioner about whether or not this was a reasonable approach to address the zoning issues. And so we didn't do this in a vacuum. We were, got advice and thought that these were reasonable arguments to make for the relief that we were seeking.
I agree with you. They're reasonable arguments. I'm just not sure that they're in compliance with the bylaw. And that's the issue. I think you need to show us that it's either in compliance with the bylaw or there's some clearly grandfathered non-compliance with the bylaw that we can be comfortable with. Otherwise, we can't help you.
So there's one other solution to this problem, which is that I believe, and Greg's going to correct me, we actually have one parking space located within the front setback. We could relocate that one parking space to the rear of the site and put the dumpster where that parking space is located, but we didn't think that anyone wanted to see the dumpster at the front of the site along South Main Street. I mean, so there, we're trying to trade off things here.
I'd have to do a measurement. You only have one space. They have to be 25 feet back from the street, as you know.
Again, I'll defer to Greg. This is his area of expertise.
Give me just a quick minute to open the plan here.
Yeah, I'm referencing, and you can, this might help you, 73A1. In any R district, all parking must be at least 25 feet from all street and lot lines.
So within 25 feet, there are 2 parking spaces. Within the front yard setback, there is only 1 parking space, however.
Well, this doesn't talk about front yard setback. It talks about 25 feet.
So there are 2 located within 25 feet.
Okay. I mean, Adam, you know 10 times more land law than I will ever know. So I absolutely have no pretense about being even close, even in the same room in terms of capability. But as you know, in zoning laws, 40A and a number of other cases make a big distinction between structures and uses.
Yes, sir.
I know that in 8.8 and a couple of our bylaws, we sort of talk about uses strung out in a sentence, but what applies, I just, as you help guide us through this, we must not confuse the word structure with uses.
No, thank you very much. I appreciate the compliment. I don't think it's warranted. I'll give you a good run for your money on wetlands and other environmental issues.
Oh,
but I don't hold myself out as an expert in zoning. I've always considered, and I've approached this project that the parking is really a use, and that's what appropriate to extend the parking use. There's no question that there are dimensional aspects to parking. It's, the bylaws less clear about that. 48 section 6, I think, is less clear about that. And so that's why we thought that it would be appropriate to deal with it under 8.7 as an extension of the use. And that use doesn't comply with those dimensional requirements, and I can't speak to when those particular requirements were adopted. But I can do that exercise over the next week if I can get access to. I have most of the historic bylaws, but I can try and do that exercise. I'm not sure where it takes me.
I don't know either. I mean, you'll find that the 5-foot setback from a lot line was put in, I think, within the last 10 or so years. But the, some of the other bylaws in terms of parking in front and things of that sort of been there for 50, 60, 70 years. But at any rate, so as Mike said earlier, there's a conflicting information. We got some letters today, which you may not have even seen, or I just got them about a couple of hours ago from 3 abutters. I mean, whatever her name is, Goodson or something, the Afters, and Mr. Bernstein, who runs the auto repair shop next door. So all this has to be sifted through and digested and evaluated.
No, and we recognize, I have read those. Obviously, all of the parties have their own vested interests at heart. I'm not criticizing the abutters for taking the positions. I would suggest that they may not have the personal knowledge of some of these events that Mr. Schiavello and people who provided sworn testimony under oath have provided to the board. These are all well-meaning neighbors that are appropriately looking out after their own interest and the interest of the town. But when you weigh evidence, I suggest that you test that evidence by determining whether that person may have personal knowledge regarding the events that they're speaking to, and more importantly, are willing to provide that testimony under oath and pains and penalties of perjury. And so, but I mean, this isn't a legal proceeding. It's a quasi-judicial proceeding. You do obviously take testimony. You have to weigh the merits of that testimony, but I just observed that Mr. Scavo's got his hand raised, Mr. Chittick. So again, I don't want to usurp your responsibility.
Well, I mean, you had me so mesmerized. I was focused on you and everybody else was a blur. Okay, John,
Okay.
fire away.
I've obviously been in that neighborhood for 41 years. Mrs. Goodson has only been there maybe 12, the same as Mr. Bernstein. So I believe my testimony far outweighs them, and the Ashers have maybe been there close to 30 years. Can anyone in the neighborhood say they've been there as long as myself? I would like them to speak up, because I believe I am the elder in the neighborhood that's still alive. Like I said, I've been there for 41 years.
Okay, no,
And I'm a very reputable person. That's
oh,
all
no
I can
one's saying
say.
you aren't. No one, there's
No.
no, I haven't heard
And,
any.
I read something about how I figured out the height of the original building, that I was not licensed. I am a licensed, registered professional engineer, hoisting engineer with the state of Massachusetts.
Great.
That's how I use the math to figure out the height of that building. You can look my license up on the state of Massachusetts website, and I've been a registered hoisting engineer for approximately 40 years. And now I'm semi-retired in the real estate business, but I still do this from time to time. I just did my 12 hours of continuing education. Unfortunately, I had a birthday Friday, and I renewed my license.
Good, congratulations.
Thank you.
Jen, you had a,
If I may, Mr. Chairman, if we could move on to, we have a pretty heavy agenda, but I also wanted to bring back the conversation regarding the abutters. I had spoken with many of the abutters, the two, Mrs. Ashfur and Mrs. Was it Michelle, and anything I had in advance of the hearing was sent out to the board last week with addendums on Friday, and then additional information that came in over the holiday on Monday and Friday, and I sent those out as well. If the board wishes to there are members of Michelle Goodson is here, as is Connie Asher, if they wish to speak, but I just wanted to make note that if it's already been noted in their letters, that we shouldn't be repetitive, and the board is going to take all of that in consideration. You have a lot to read, a lot came in. So I just wanted to ask you how you'd like me to proceed.
well, what I'd like to do is perhaps jump in ahead of them just a bit and ask John Hallen if he has anything to add or comment on here. It's not required, but you've been very patient, John, so do you have any comments or suggestions to make at this point?
No, I think the comment you guys have made already is, again, reviewing the parking history and finding out exactly where it was, and then the two spaces that are currently in the setbacks, and is that the relief that the applicant is seeking. I think the size of the footprint was kind of determined earlier in the conversation, and again, the third thing, the use, if you see it as an increase from 2 units to 3 units, even though the square footage is the same in the residential use. So that's those are my only observations.
Okay. Jen, let's turn it over to if there's something new that either Michelle or the Ashars would like to add, we'll do so, but we do have the letters in hand.
Right. All right. I'm promoting Michelle Goodson now. Michelle, just a reminder that if it would just be new information, not items that were listed in your letters that the board has.
Fine. Can you hear me? Hello?
Yes.
Yes.
Okay. So you can hear me. So I guess, I mean, there were a lot of items that were brought up. I mean, I do have concerns about the height of the building. I did forward some pictures out my second bedroom window regarding the previous height of the building. I know you guys have to sift through all that stuff, so I would just like to make sure that somebody looks at that. The second thing, I really take sort of onus on Mr. Chavo's assumption that the abutters are ignorant and do not have any knowledge.
Wait, slow down just a second.
Area.
Slow down.
I grew up
Michelle.
in Cohasset.
Michelle, I should have said at the outset, it's our practice that we don't reference or make allegations or comments on somebody's observations. We're trying to be factual here. The time for resentment is not now, or
I'm not resenting. I'm just saying that when someone talks about being the only person in the abutting situation of having knowledge of the area, that's very unjust. That's not the case at all. I mean, we've all been in this area for well over 30 years. And the fact that he keeps implying that that I've only been here for 3.5 years, et cetera, is just untruthful statements.
okay. Well, we have that comment.
I'm just
then.
bringing that. Yeah, so I would like to just reiterate that I've been in town for well over 30 years. And I'm very
But that's a good factual statement, and I appreciate it. Thanks.
Yes, so I've been in town over 30 years, and I've lived next door for 3.5 years. So I think somebody living 4 feet away from the property can have very factual information to attribute to
Correct.
the whole scenario. That's all I'm really
Okay.
trying to get that. Okay.
Yep.
And thirdly, I guess I'm very concerned about the comments regarding, I checked the registry of deed going past 99 years. It's my understanding that the building was always deeded and registered as a commercial space, not as a residential space. I also checked with the post office. They had no legal post office address for anything but a commercial building next door. I don't have any, I couldn't find any legal mailing addresses for these 2 units that were located upstairs. And I don't know. I mean, it feels odd that these assumptions about this being a legal use. I don't know. I don't know. I'd like to see some sort of information saying that these were ever inspected by the Board of Health as legal residences and sort of all of that. I mean, to Mr. Chaddock's point, I'm not sure that the assessors or there were taxes assessed for residential units upstairs. And I just quite frankly don't understand how they could be giving the use to put residential units as something that's always been there. I guess that's another question that I would propose.
Right. And what we can't answer sitting here tonight is whether they had that permission or not. We know that we haven't seen much, but that doesn't mean it doesn't exist. And we're going to have to do some more digging, I think.
Okay. And then lastly, the parking. I would just, again, without being repetitive, these spaces will be directly in front of my home, very close to my bedroom and my living room where they're proposed. And I have grave concerns about that. And again, I will just allude and end this with, in all the years I've been present around this property, I've never seen more than 2 to 3 cars in front of the building. And I've given you pictures as well. So that's
Okay.
it.
I appreciate it. Now, are there other people, Jen, who would like to speak?
Connie Ashford wrote and said that she feels that her letter says everything that they wanted to say, represents how they were feeling.
Okay.
I'm just going to see if let me just see. I've got another hand raised in the attendees. I have a Stephen, but I don't have a last name or address. So if they could use the Q&A feature. Otherwise, we can just ask them to send something in.
Yeah, I think we're
Okay.
going to have to digest. We've gotten so much information
Right.
in the last few days that we're going to have to go through this. Adam, if you could enlighten us, I would make a motion that we continue the hearing. If you could enlighten us on this change from 2016, that would be very useful, and that'll give you a chance to take a look at it's not a 2014 decision, 2004
Yes, sir.
decision.
I promise to do that.
Well, yeah, I mean, it's actually a very easy read. So that I would like from you. I don't think we need any more affidavits. We have some conflicting testimony, but that's not unusual in situations like this. Dave, is there more information you'd like to see? One way or another?
Well, I think the two things that are of greatest concern to me at this point are whether or not the dimensional issues related to the parking are grandfathered in any way and how that can be shown. And secondly, whether what the law is on the, let's just assume that they were illegal apartments, what the law is on whether that has grandfather status as well. And if you can show that they were legal apartments, then that other issue is moot.
Yes, but. Okay. So with that, I think we need to sift, digest, and dig a little deeper into the parking and probably put our thinking caps on in terms of the nature of the change in use. Is it significant or not? Is it substantially the same or not? And we're not going to decide tonight or even further debate it. I think we have to think about that because it is not engraved in stone. There's certainly a judgment call here. Yes, Jen.
Do you mind, Cindy Amara just has her hand raised just before we
Oh,
close.
I'm sorry, I didn't see you.
That's
okay. I just wanted to clarify one thing. When people keep talking about the standards in 8.8 and whether the change is substantially different in character, I just want to read that there's also or in its effect on the vicinity. That's also part of that first test before you get to that it won't substantially be more detrimental. So it's that it's not substantially different in character or in its effect on the vicinity. And I just feel that I haven't heard anyone read that part as well. And I just wanted to throw it out there that that is also part of the bylaw.
Oh, yeah.
Anything else?
Somebody speaking, but Adam, do you want to, I mean, is it worth your addressing that point or?
Not at this time, Mr. Chick. I did address all of this in more detail in our application. I did a lengthy letter in support where I touched upon each of the requirements and articulated to the best of my
That was
ability.
back in February?
Yes, sir.
February letter memo? Mm-hmm.
Yes, sir.
Okay. The only thing we should note there is we're taking off the table the 14.4 relief.
Correct.
Okay. Well, I'd make a motion to continue this hearing until.
Actually,
July.
what he did, so
Oh,
did,
sorry.
just Jen, I did see it just in the chat there, right? The gentleman had provided his last name. Is that?
Oh, there's one other person who wishes to speak. It's Steve Bjorklund. But you had already made a motion to close, to continue, so I can have him speak or.
I wonder if you could put something in writing just so we could move on. We can deal with it next month.
Stephen, do you think you could do
Would
that?
you be willing to do that?
Stephen, could you write us through the Q&A and let us know if you can submit something in writing, and that way we can get it to everybody. If you want to send it to me tomorrow, I'll get it out to everybody, which we have a huge agenda. He has not written me back yet. Oh, he's going to do that. That's great.
Great, thanks, Steve. Okay, so I've made a motion to continue until July 14th or whatever. 14th?
13th.
13th, almost Bastille Day. Okay, do I have a second?
I'll second it.
Okay, Matt seconded. All in favor, Woody Chidick, aye.
Dave McMorris, aye.
Matt Watkins, aye.
Michael Dickey, aye.
Is Lee?
No, Lisa recused.
Oh, recused, so it's Charlie.
Charlie Higginson. Yeah, I muted Charlie.
Okay, Charlie, you in favor?
You can just wave.
Just wave.
All right.
Let us know you hear us. Okay, well, it's 4-0.
Great.
Okay, all right, let's move and seconded him and voted 4-0 to continue that hearing. The next one up is again, filed by Adam Brodsky on behalf of his client Brian Crumley, a dock, 137 Nichols. We started that a couple of months ago, and last month, I think we continued the hearing without getting any new information. So Adam, do you want to take it on from either where things stand or where we left off back in April?
Thank you, Mr. Chittick. Adam Brodsky and I represent the applicant. We asked for a continuance last time because we're working with the Rutledges who had concerns regarding the project. I can report that we have reached an agreement with the Rutledges that has been reduced to writing. The parties are in the process of signing that agreement. So the Rutledges should no longer have any concerns regarding the project. There's no additional information to present. So we'd ask the board to please close the public hearing and issue a decision.
Okay. Okay, make a motion to close this hearing at 137 Nichols.
Actually, Adam, just one
Oh,
question.
sorry.
One question I had on, and I might have had it wrong in my notes, but was there also an issue with 135 Nichols, Mr. Paul? Is that, or did I have that name wrong in my notes? Sorry.
No, Mr. Paul had some concerns. I've been in communication with Mr. Paul. I haven't spoken with him recently. So I have nothing to report with respect to Mr. Paul, but it was the Rutledges who had appeared and had, I believe, expressed concerns. I've been dealing with their counsel, Matt Watsky, and as I reported, we've reached agreement with respect to their concerns.
And is that concern that you've reached agreement with, that's clarification of the rights associated with that 100-foot wide
Correct.
right of way depicted on the site plan?
Correct. Again, not necessarily a zoning issue. It was a concern regarding their rights under that right of way and easement. And so we've reached an agreement with them to address their concerns.
Okay.
Do you want that agreement? Is it appropriate to have that agreement referenced in a draft decision or not? Or is it better to leave it as a side?
Yeah, I'd have to ask. I'd have to ask Mr. Watsky. It's private property rights, not.
All right. Well, then we shouldn't muck with the zoning decision, I don't think.
Thank you, sir.
Okay.
And we don't have anyone, right, who's from the public for this case that has any.
I don't see any names that I recognize. No. And there's no one in the Q&A.
Okay, so I've made a motion to close the hearing. Continue the hearing till next month.
Close it.
Decision.
We can close it.
Close it.
Okay, close it.
Yeah, I would second.
All right, Woody Chidick, aye.
Lee Darcey.
Dave McMorris, aye.
Matt Watkins, aye.
Michael Dickey, aye.
Okay, can we get Charlie unmuted or not?
I just asked him to unmute.
All right. Well, we've got a 5-0 vote to close the hearing. No sense dragging this out. Okay, the next hearing is 51. Sorry, Cindy, do you want to say something? Okay, 51 Gammons Road to construct a dock.
So you've already closed this.
Yeah.
So you're good.
Okay, so we have nothing more there. We have, we didn't close 61 Elm, and I'm recused anyway. So I'm going to recuse myself. I don't remember. Did we close this hearing?
We did not.
No.
You did not know.
Okay, I'm going to turn this over to Dave McMorris, who will take the chairmanship, and I'll mute myself.
Okay.
All right. John Teriyaki is the applicant on that. So I'm just promoting him so he can answer if there's any questions.
There you are. Hi, John.
Hi, good evening. John
Do you have
Teriyaki Architectural Design.
Do you have anything new on this one?
We don't have anything new to present, and I'm happy to take any additional questions since last time.
All right. Anyone on the board have questions?
Um,
No one? Okay. Jen, is there anyone in the queue?
No, no one in the public to speak with their hand raised or in the Q&A.
Okay.
And
So,
I have a question. Charlie Higginson,
okay, Charlie?
am I muted
You're
or
on.
not?
Yeah, we can hear you.
Okay. To Mr. Teriyaki, what would be the height of the first floor room at the where it abuts onto the, well, close to the driveway?
Sure, let me share my screen real quick as I give you that calculation. I believe you were asking about this piece right here.
Exactly.
Yes, let me just open my CAD file and give you the exact height. From the average grade, that piece measures about 12.5 feet in height.
Fine, thank you.
You're welcome.
Any other questions from anyone? Hey, Charlie, you have a draft on this one, right?
He does.
Okay. Then I think it's appropriate to entertain a motion to close this hearing on 61 Elm Street.
So moved.
Lee Darst moves, second.
Charlie Higginson, second.
Charlie seconds. All those in favor? Dave McMorris, aye.
Lee Darst, aye.
Matt Watkins, aye.
Michael Dickey, aye.
Charlie?
I voted aye.
Okay. So we've closed 61 Elm. Next is 30 Whitehead Road, and I think Woody will be back for that one. There he is.
Back for that one. So this is a special permit and a variance filed by James and Charlotte Bedell to construct a shed within the front setback. And I guess who's representing them, or are they representing themselves?
We're representing ourselves.
Okay. So the big complicated, the variance is a big issue, and I presume you know what the variance requirements are and can speak to those. Why don't you tell us what you want to do in about 2 or 3 minutes and why, and then why you need the 2 kinds of relief you've requested.
Well, the 2 kinds of relief were, Jen might be able to speak to this, but there was some confusion with John Halen and Jen about what we actually needed for this shed. So we applied for both so that we were covered, so that which way we were required to go was handled. We wouldn't have to come back if we had filed this motion in the wrong form.
Sure. Okay.
So we may only need one. I don't know. Maybe we need both, but that's why both are listed. What we're proposing to do is build a 20 by 14-foot shed, 30 feet from the road, which is a setback. We're a zone C. We actually intended to not be in front of the zoning board. We had actually intended to have the shed adhere to the frontage, but that put us in an isolated vegetated wetland. So we went in front of Conservation Commission. The entire structure was inside the setback, and they were not. They asked to work with us to move it out of the wetland. So we actually reduced the size of the shed at that time from 20 by 16 to 20 by 14. and we moved it forward so that a very small portion of the shed remains in the wetlands. We're asking to build this on an area that was previously altered. It's sort of an auxiliary driveway that was altered at some point in the past. I don't know when. And they allowed the shed to exist partially. I think it's about 30 or 40 square feet within the wetlands, only because it was an already altered area. So that has put it on in this board's jurisdiction. The reason should we get into the reason for the setback is our frontage. In the 1950s, a larger parcel of land was broken up, and our parcel was created, and the house was built upon it. In the 1985, the house was put up for sale by the previous owners, or those owners, and a neighbor purchased the property, stripped off anywhere from the entire frontage between the road and the property, gave an easement to my property for crossing for vehicular traffic and walking anywhere along the property, and then sold the property to the owners who purchased it before us. So even though the shed we're proposing is 30 feet from the road, it's only 13 feet from the front of our property, which is interesting. And the other reason for this location is so we have 67,000 square feet of property, but almost 90% of it exists within the 100-foot buffer, the IVW, or is restricted by the house and residential zone C setback, which is 20 feet to the sides, rear, and 30 feet from the front. So that in a nutshell is what we're trying to do.
Who owns that strip of land that, whatever
Our
it is,
neighbors.
70, what?
The neighbors across the street. So they own essentially the strip of land on our side of the street, and they own all the contiguous land on the other side of the street as well. It's the Thayer's property.
I don't know. We won't take the time tonight. I haven't run into a situation where somebody basically took legal frontage away and made unbuildable lots out of a whole bunch of land and then sold it.
It's definitely unique.
I mean,
Not thrilled
technically,
about it.
technically, but your house predates this move.
Yes, it does.
Somehow land court approved it. I mean, that's another issue, but you may well need a variance. Well, do you want to speak to the Section 8 relief? Or maybe John can explain why Section 8, and Section 8, Article 8 is a chock-a-block full article. What subsection are you seeking relief?
Section 8. We were looking for 12.5, 312.5.
Okay, so this is strictly a variance. It's not a special permit.
I put in section 8 to cover a non-conforming structure. That's how they filed it. And then I added the variance because I didn't feel it fell under that. So we advertise under both. And then you're advertised that you can give relief under anything else.
Right, anything else, you just can't go up.
Right.
So, okay, fine. So talk to us about variances. There are 3 tests of variance that you have to meet sequentially.
Well, the conditions and circumstances are certainly unique in that we don't have the frontage. This issue, there's a buildable lot next to us which doesn't have this issue, and another lot west of us that doesn't have this issue.
Why don't they have this issue?
I'm sorry?
Why don't they have this issue?
The one of the property is actually 1.25 acres and abuts the road. And the other property to the other side of us also abuts the road. So they're in that sense conforming.
Well, they have legal frontage. So what year did you buy this land?
We bought the house in 2018.
Knowing that it didn't have legal frontage.
We did not know that at the time. That became apparent to us when we did the survey. And I actually asked the surveyor why we don't own to the road. I have a survey I can show you. And he couldn't explain why. So I did call the assessors and they said, oh, well, you know, there's this piece of land here and you don't own to the road.
And this didn't come up when you were closing on this property?
No, it did not.
No title search was done?
I don't know if the title
There's
search
good
was.
title.
Yeah, there's good title. It's a clean title.
Clean title to a lot that you can't build on, but other than that.
Well, there's an existing house on it.
Yeah, I know. That's grand. That's protected.
Yeah.
Well, so speak to us about the variance test. It's got to be really soil topography shape of the lot. And I don't know if this qualifies or not. This is an unusual situation. We'll get into hardship and things of that sort as a third test, but in a moment. But let's deal with this one. What makes this so unique?
I'm going to pull up the topography.
Oh, yeah.
I'm going to share my screen.
Sure, Jen, that's okay, I presume?
Yes, you have permission as a panelist.
Okay. So this is a copy of our survey, which we have marked up. So as you can see, the heavy black line that runs along the bottom or the south of the screen is our property line. As you can see, it does not go to Whitehead Road. All right, does not abut the road. So the red line is the 50-foot buffer for Treats Pond, which according to Concom, that's a no-go zone. I mean, you're not going to build in there. They don't want anything disturbed.
Okay.
The yellow line is the 100-foot buffer. The Conservation Commission, with certain restrictions, can allow and has allowed us to build within the 100-foot buffer, provided that we meet whatever criteria they deem necessary. For instance, doing some plantings, putting up sill socks, things of that nature. So within the 100-foot buffer, we do have a Concom variance for this shed. The shed location was approved by Concom. The green location is the setback for the isolated vegetated wetland, which is also, that's the wetland and a 25-foot buffer. And generally speaking, anything within the 25-foot buffer of a isolated vegetated wetland is a no-touch area. Again, we originally put the shed entirely in the isolated vegetated wetland, and they asked us to move it, and we did. And they did give us the variance, even though a portion of the shed would exist within it, because of the it had already been altered, which they were very clear about. They only granted us because it was an area that had already been altered. The dark blue area is the 30-foot setback from the property line, from our property line, and the 20-foot setback on the left and the right of our property line, which is a restriction for a building. You can do a shed within the 6 foot of the property line, but it would obviously be substantially smaller. And the other thing is that a shed would run into every other restriction, the 100-foot buffer, the 50-foot buffer. The only legal area to put the shed is the light blue lines in front of the house. The turquoise. The location of the shed we're proposing is over where it says gravel driveway, essentially right here. And I have a picture zoomed in of that area, which is right here. So again, this yellow line is the 100-foot buffer. The green line is the 50-foot buffer. And the red line is the 25-foot buffer for the isolated vegetated wetlands. As you can see, a small corner still exists in it. These lines here is indicating an actual wall. There's at some point when they built this auxiliary driveway or this gravel driveway, they laid it out with boulders along the back of it. So if you were to walk around behind it, you would see a lot of large rocks that are holding the soil there. And then they filled this whole area in with sand. I've actually, at the time, I dug a test hole for one of the pilings, and I hit very few rocks, which is, it's not cohasset, the normal cohasset soil. So it's definitely fill. And as you can also see here, this heavy black line is my property line, and the neighbor's property is not listed here, but it's obviously between there and the road. The reason that the strip was purchased is the woman who did it has died. I've reached out to the current owners, who are her daughters, and they have no idea why this was done in 1985. There's no documentation as to why this was performed. Nobody can even venture a guess.
Okay. All right, well, I think you've talked about the soil conditions, maybe, I mean, as being sand. I don't know if that qualifies or not, but.
It's fill.
Yeah, Phil. Board, do you want us to deal with soil conditions, or do you want to move to hardship? As test number 2. Anybody on the board?
I mean, I think as far as soils, that they may not have much more to tell us. I guess I'd be open to listening to the next case. I mean, the next condition. I guess I will just, with a little bit of explanation, let the applicant know, just somewhat candidly, that like variances are a very tough criteria for us, right? So we need to really scrutinize these 3 areas. But, to your credit, I mean, I think you're explaining it how it is, and you know what I mean? You're presenting your case. It is a unique parcel. I don't know how much more you can say about soil there, quite frankly, so.
Yeah, I mean, we wouldn't even come up before you except for the fact that we're 30 feet from the road. So if we own this property, we wouldn't be here. So that's all I can say about that.
And to the untrained eye, it is part of your property. I mean, it's, nobody would know without a plan of this sort.
Yeah, it didn't come up until we did the survey.
On that strip. But, okay, the second test of this is hardship. It can't be a self-created hardship. Speak to us about why this is, and also the other issue of a hardship. It isn't maximizing use, it's preventing your use of the lot in some way, shape, or form. So it's a pretty tough test.
Okay, understood. Well, the location is defined. I mean, the hardship location wise would be, I would think would be self-determined by this map. I mean, there's really no other place to put it. Then the reason comes down as to why we want it. So we're building, we're constructing a house there, right? We're putting an addition on the house right now. And again, we got Concom permission from that. And we're putting in a 2-car garage. And the rest of the space is livable space, obviously. And I have a lot of stuff. I mean, we're not looking to put a car there. I'm actually looking to make storage for seasonal items, lawnmowers, snow throwers, kayaks, ladders, a lot of my tools. I would probably use it as a wood shop, which I cannot get in the 2-car garage. And I mean,
It's seasonal.
It's just
storage,
seasonal
for the
sports
most part,
storage.
bicycles,
Yeah, bicycles.
kayaks.
We don't have that stuff. We came from another house over on Fernway, and we had a 2-car garage, and it wasn't enough space. And we like more space to store the things that make our world go around. And again, the driveway is a logical choice, but obviously not a hardship choice. We started this process with the best of intentions, not realizing we were going to have to go in front of the zoning board of appeals. But again, here we are. I'm, as far as hardship goes, that's.
Can I throw a maybe friendly monkey wrench into this whole thing? The lot line that we're talking about a setback from, we're talking about it being within the 30-foot setback from the front lot line. This lot line does not qualify as a front lot line under the zoning bylaw because it doesn't front on a road. In fact, none of the lot lines on this lot qualify as a front lot line.
That is true.
So, I mean, let's just for purposes of talk, look at the opposite lot line. If we call that the front lot line, then you don't have any problem with the shed because it's less than 15 feet high and it's farther than 6 feet from the actual lot line, and it's more than 100 feet from what you are
You mean,
using.
you mean if we go due north on the other side of the lot?
Yeah.
That's 50-foot buffer. That's Treats Pond.
Yeah, but that's.
You don't have to build there.
You know, no, you have to measure from there. So if you measure from that lot, you're more than 100 feet from that lot line, and you're less than 15 feet in height. So you can go within 6 feet of the other lot line by right.
Oh, so you're saying call the back lot line the front lot line and go 100 feet back?
You can,
Because I know it's
under
100
our
foot
bylaw,
setback for sheds.
yeah. Yeah, if you're more than 100 feet from the lot line and it's less than 15 feet in height, you can go within 6 feet of either the side or rear lot lines.
Yes.
So, I mean,
I didn't know I could. I completely understand what you're saying, and it hadn't. I mean, if the building inspector or if the board sees that they could read the lot lines that way, I mean, there is no. I mean, technically, there is no frontage anymore. So.
Right, there's no front lot line by our definition.
So yeah, I mean.
And there's nothing in the bylaw that says you have to declare your legal front line as Whitehead Road or something. It's.
Yeah, there is no frontage. I mean.
Most people, yeah, if you fronted there, you would have to, but without any frontage.
I hadn't even. I mean, I didn't know that that was.
No, is John Hallen listening in? Is he still, Jen?
Yes, he's still here.
John, what do you think? Do you think this is? I know it's.
I think it's such a unique situation because I don't. Well, as you said earlier, I don't know how they were able to even purchase the land there, but in the situation, it's not like we have a rear setback that we need and a side setback. It doesn't, it doesn't have a front yard setback. So I think David has a great point there. As a kind of way of seeking hardship or of getting beyond that and looking at it from a different setback here. I would agree with the logic.
Yeah, the shed does conform to. I mean, the shed does conform. At the peak of the shed is 17 feet 2 inches. The midpoint of the shed is less than 15. So I mean,
I'd rather avoid
criteria.
I'd really rather avoid the whole variance issue because it's, I
You probably
we'd have to stretch. I'm sorry, Woody, what?
I was saying you probably can't get to a variance, frankly.
I think the hurdle's too high.
Yeah.
Then may I mention?
Go ahead.
I just want to say, if that is the case, then it would make a lot of sense to have them withdraw without prejudice this evening before any decision is even thought of.
They may not need a decision.
Right. And so we don't want, because of timelines, the Bodells have been kind enough to give us a letter for extension anyway, but if we don't even need that, I would recommend the board do that if this is the way you want to go.
Well, let me ask the board. I mean, Dave's, I hats off.
Sorry, David, I'm
that was not going to occur to me. But now we have a lot without frontage, which is certainly unique. Do they even need relief to put a shed, 100 feet back that's less than 15 feet high? I don't think so. That's by right. John, Helen, would you see it that way?
Yes, I think we would. It would gotta be a shed again. I think go within 6 feet of it, the 13 feet from it, the height. Again, at 13 feet, I believe, to the midpoint would satisfy that.
Yeah, I think you can probably do this by right. But if somebody on the board or John says, wait a minute, Woody, you're wrong, please speak up, because
I mean, I guess there's nothing in the bylaws that defines, other than a road, that defines a property front.
correct.
And we don't have that, as you said.
I mean, 'cause the question is, unless somebody on the board has a serious reservation about it, if John issues a building permit, then they build it.
I don't have a reservation, but let's hear from everybody. This is a democracy. Lee, are you still here, or is she?
I am here. I don't have any issue with it. I think Dave's analysis was great, because I know I got bogged down by all the lines, the lot lines. So thank you, Dave.
Matt, any issues, or Mike, Dicky out there? And
No, I don't have, it sounds like could be grounds for a good solution, so I don't have any reservations with it.
It's a wonderful solution. I don't understand why you don't need to have a front lot line.
well, a front lot line, yeah, technically fronts on some sort of a way or a street. If it's fronted on a driveway, you might not have a front lot line. Because driveways usually front on a street or way. I mean, we do have properties in town, Charlie, that don't have, that are not really a legal street, but, our definition of frontage is a length of line dividing a lot from the right of way of the street on which it bounds. Well, it doesn't bound in any street.
And if you look at the definition of front lot line, it's similar.
Front, yeah.
Lot line front.
So yeah, you could have,
somewhere in the zoning bylaws, you do have to have a rear lot line. I'd have to read further to see whether you don't have to have a front lot line.
I think you can, there's no frontage here. And there's no lot line that meets our definition of a front lot line. So it seems to me that there's some latitude to declare any line they want as the front lot line.
yeah, it says the property line dividing a lot from a street. Well,
There isn't
there isn't
one.
one.
Mhm.
So they have a non-conforming house. When was this house built? I'm just curious. It's not germane.
1955.
All right, so why don't we just say it's a pre-existing non-conforming house? It's just one of those anomalies. Although it's, why that lady did what she did is not for us, but it's strange.
I would love to know why.
Maybe they'll sell it back to you someday.
Yeah.
Not doing them any good. They can pay taxes on it if they want. But at any rate, I think Dave's solution is pretty elegant. I don't see any problems with it. Charlie, you have a reservation a bit.
Yes.
But if you take the letter of the law, the bylaw.
What's our town council think?
Yeah, where's Cindy?
Cindy's raising her hand.
Here, I'd like to think about it a little bit. I'm sitting here struggling with the whole concept that their lot has no frontage and what that means. I like the solution, but I also, for some reason, have a little bit of reservation, and I'm also wondering if there isn't anything that a close look of the language of the bylaw with a close look at the language of the easement might also help support to get you to the same place as well. I would want to be able to look at the definitions with a little more time and specificity. But I like the solution, and I also like your solution. See if people will sell them back that frontage.
That isn't going to happen in time to help them put up a shed, you know, by the time the wheels get rolling on that one. I don't think.
I don't know, and I don't
That's
know if it's even mutually exclusive, but in the long term and
Yeah.
the scheme of things, I don't think that's such a flippant response that you made.
No. That is what I would do if I owned this property. I would move heaven and earth to buy that, you know, unless these people were trying to hold me up. But they're paying taxes in something they can't use. Well, why do they bother?
Right. Well, and you might also be able to get the variance issue on shape, right? Because the shape is such that you don't have a lot that's fronting on a way. But if you were to go to what would normally be the frontage, you've got the distance from that point to where you want to put the shed. So there's something very unique to me about the shape of this lot as well. I mean, I think that, you know, David's got a really good idea. I would just want to spend a little bit of time seeing how you can flip around the front and the back lot line.
I feel a little less offended by the lot line solution than I do by trying to stretch for a variance.
Yeah, I don't think they can make number 2 hardship.
And I don't think there's going to be a lot of people running in to use the same solution, because I don't think there's a lot of properties that don't have a front lot line. So.
Well, I think on the variance issue, I think the hardship might be an issue more than the first prong, because you really don't need a shed.
That's right. That's what I mean. I don't think they can meet the hardship test. I think this would be a solution. If you want to mull it over, please do. But I would, maybe I'd recommend that we continue this until July, and you may wish to withdraw without prejudice, which means that you could always come back to us. But if a serious objection to Dave's alternative does not surface, in other words, if people sort of buy into that, you could simply withdraw your application, go ahead, apply for a building permit, and be done with it.
And they wouldn't have to do that, Woody, until the time that we were ready to make a motion to close the case either, right? I mean, is that?
Well, they can,
I mean, in other words,
they need our permission to withdraw.
Yeah.
Without prejudice, but we don't have to have the hearing closed. They could do it midway through a hearing. I may be missing your point, Matt.
Yeah, I was just making sure. I mean, there's not like a sense of urgency on their behalf that they have to do it by a certain time. In other words, if the meeting gets continued and they're on the agenda for the next meeting, the same goes. They can still ask to withdraw without prejudice.
Right, and they could in fact do that when the agenda is being prepared, and all we'd have to do is vote to accept their withdrawal without prejudice.
Yeah,
and they could apply for a building permit in the interim.
Yeah.
And I think we need to continue anyways because of the closing and the 14 days.
Yeah.
Okay. Well, but we haven't closed this yet, have we?
No, I'm just saying that's what you're heading. I don't see anybody in the audience.
Yeah. So why don't we do that? And Bodell's, why don't you at least sit down with John when he has a chance and seek a building permit, see if you can get a building permit. And we're going to wait for Cindy to come up with concerns or Charlie, you know, but if those concerns are not significant or evaporate, you know, with further thought, sometime between now and July 13th, you could you could request withdrawal without prejudice, meaning you could always come back at a later date. No harm, no foul.
Hey, Woody,
Yeah.
just quickly, and again, I got hats off to Dave for, you know, thinking outside the box, if you will. But the one thing, and again, I'm speaking with no expertise at all, but it occurred to me, the one thing I'd be concerned about if I was the Bodells, especially since it sounded in their description that they're having some other stuff done, that by kind of declaring what would normally, you'd normally assume it'd be the front to be the rear, that doesn't kind of have knock-on effects that would affect some of their other plans, where, and by that I mean maybe there's something that they want to do that they will not be able to do now because it's too close to the rear of the property, that type of thing. Do you know what I mean?
Yeah, I do. I don't know what your plans are, Bodells.
Yeah, but that's the one thing I'd want to check out if I'm the Bodells. Make sure that by declaring, you know, kind of declaring that this is now the back of our lot, is that going to somehow have a knock-on effect on some of the other stuff we want to do in what is now our backyard?
Just to answer that one, Michael, I think in reviewing the plans, the other work is set back much further, so I don't see any concerns there by that change.
Well, good. Well, I wouldn't have thought so, but that
Now's the time.
that you want to make sure if you're going to call heads, you just want to make sure that there's no kind of knock-on effects that you didn't think about. That you know, now you've declared that the front is the back, or vice versa. You know.
Yeah, I would move that we continue this until July 13th, and in the interim, there's some work to be done on the part of the Bodells, sitting down with John and Cindy and Charlie. I don't have any reservations, but that doesn't mean anything. You know, and we could kind of get a sense if there's something we're missing, a la Mike Dickey's point. If not, they could probably. I don't see.
I would second that continuance. I just wonder. I'm worried about the precedent where we might be setting, allowing to have no front line.
Well, you have to have frontage. I mean, if you want to build anything, they're in a very compromised situation right now, not having frontage in any way. They can say the front yard or whatever, the front lot line is here, but that doesn't give them any buildable rights. You know, I mean, I think they've got an ongoing problem that they could solve by doing what Cindy was talking about, is just buy that strip of land at some point. I would want that as insurance. You may have a hell of a time unloading this property without that. But there's plenty of time to do that. That doesn't have to be done tomorrow, if you know what I mean.
And if you did buy that strip, your shed would be more than 30 feet from there anyway, so it's still.
Then you'd really comply.
Yeah, it already is, so.
Yeah, well, let's proceed down that path. I would make a motion to continue this until July 13th.
Second.
Okay, moved and seconded. Woody Chidick, aye.
Lee Darst, aye.
Charlie Higginson, aye.
Dave McMorris, aye.
Matt Watkins, aye.
Okay, unanimous, 6-0.
Oh, you didn't. Yeah, I had to come in with my eye too, Woody.
Oh, I thought I heard you say aye.
No, there's some crosstalk, I think.
Oh, okay. All right. Mike voted twice. Let's put him down for 2 votes.
All set.
Okay. All right. So there you go. We may or may not see you next time.
We appreciate the creative thinking.
Okay.
Thanks.
Okay. So our next is an appeal.
Actually, we're on 11 Jerusalem Road.
Did I jump ahead? Oh
You
yeah,
did.
I'm sorry. getting so excited here. 11 Jerusalem Road, a special permit request. So I suppose Jonathan Paulstrom.
Yes, I just promoted him.
Okay, maybe he can explain what they would like to do and why a special permit is appropriate.
Mr. Palmstrom, you've been promoted. If you can unmute.
We also can't see his face. I don't know if
No.
he has visual.
Hopefully he might have gone off to get a snack.
Oh my God. You'd better hope he gets in under this wire because the next one might not.
Can you?
I know. Yes, yes.
Great. Sorry about that, people. So we're proposing an addition at 11 Jerusalem Road. The existing dwelling is non-conforming. It's a L-shaped dwelling, and we're looking to infill the back corner to create living space for the owners.
Okay, and tell us about the addition. Does it further encroach on the lot line? What about height? What about any potential violations of the zoning law other than the fact that it's a non-conforming structure and you're adding to it?
Well, it's a non-conforming structure. We're at the beginning of the new addition. We're at 18 feet from the lot line. At the end point of the new addition, we're at 19 and a half feet. We are well beyond 40 feet from the neighboring dwelling.
And what about height? You're going up 2 stories?
2 stories, but not beyond the existing roof line.
It's been a long time since I've really walked around that house. I mean, it basically is almost on a cliff, isn't it? I mean, it falls off the.
It is, yes, that's correct.
How's it anchored back there by pilings, or is it?
The addition that was put on it previously, I'm not sure the date, is on pilings. But we're proposing a footing and a foundation for this piece.
You say a foundation. What kind of a foundation?
Poured concrete.
Great, okay.
Yes.
Let me ask John Hallen. John, do you have any issues with this proposal, either the way it's being constructed or what it's doing to the lot or setbacks or anything? Well, maybe he's gone for a break. I can't find my plan, but that doesn't matter. I mean, I'm familiar with the property.
Yeah, I had just found mine actually. So I was in the same deal. I was going to ask John to maybe share the screen.
I've got a lot of plans for docks in front of me. That isn't helping. Anyway, somebody take up. Well, it's not just sit here.
Mr. Palmstrom, can you share your screen?
I'm sorry.
I have a question. How much of the addition, how much will the additional square footage in the setback would the addition add?
A reasonable question.
I'm sorry. Could you? I'm sorry. I was trying to share my screen with you, but I can't. I'm actually not in my office. I'm actually in vacation in Florida. What was the question again?
The question was how much additional square footage will be in the setback by the proposed addition?
I'm looking for that information on the application. Just give me a minute.
Okay, I do have the application.
Well, building coverage is kind of negligible because of the foundation and things. It's is this poured foundation going to go from the ground all the way up to the house, or are you putting piers or some sort of a
No,
structure?
the poured foundation will connect with the existing house.
Okay. I see you're not, building coverage is not moving very much. It's moving half of, well, 2/3 of 1%. Not a lot. That's coverage. Couple hundred feet that it's adding on the ground. What about, but can you speak to Lee's point about volume? I mean, there's a, certainly you've got a couple of floors, square footage wise. How does that compare to what's there?
Actually, Woody, it looks like this might help him out. It looks like there's some in the chat. The designer looks to be saying that it adds 488 square feet. So
250 square feet. All right, and the 2 stories, 488. I was just trying to pull up the plans, but I'm having trouble getting them.
Yeah, it would look like about 240 or so square feet per floor in this proposed addition. And there are 2 floors?
That's correct.
No, I was wrong. It's not 240. It's double. It's 25 by 20 basically, isn't it? So it's 400 and some odd.
No, it's 13 by 17.
Oh, all right. 13 by 17. All right.
I've promoted Christopher, who's the designer, and now he can be able to share information with you.
All right.
Hi, my name is Chris Diorse. I did the plans, and I can show you on the screen what you're looking for here. Here you can see the footprint of the first floor, and the addition is rendered here in pink. So the footprint is about 250 square feet. If you add the first and second floor together, the finished floor area of the addition is 488.
Okay. And that compares to the existing house of what?
Well,
and is there anything there now? Are you doing any tear down? Does it have a deck? I mean, I know it in the rear it's a deck, but
no, there's nothing there now.
So the existing first floor footprint is 1,546.
So that would be about the same as the second floor?
Yes.
Okay, so 33,050, 2,100. Okay, and this is adding, you say 500, basically 480 or whatever. So, okay, so it's about a 15% increase, something like that, maybe 20.
It's not
No, not 20. It's not 20. It's 15% probably that you're adding to the to the volume inside.
In the facade, non-conforming facade is what?
Yeah, see, I'm not sure my plan had that.
There are 2 site plans. One smaller, one bigger.
Well, it looks like the 30-foot setback line runs almost to the middle of the existing dwelling. And, I mean, a lot of this house is non-conforming.
Yeah, but what if the addition is non-conforming? Just from the sideline, right?
Yes.
It's encroaches on the 20-foot side setback
By what? Half a foot?
by 2 feet.
It starts at 18, Dave, and then it sort of goes back to 19 and a half. Maybe you could divide, maybe we could say it's 18.75 feet on average. So it's 1.25 feet intruding into the setback. It's a little more than a foot all the way along that.
Right, so basically it's the entire new facade facing the sideline and just a smidgen.
This is not affecting the existing facade to the front or
Right.
the other, or the west.
Right, so it's just some additional non-conforming facade in that little sliver of
Yeah.
setback. All right,
Yeah, I mean, it's pretty de minimis if you're encroaching on the side, if you're extending a nonconformity a tad away from where it is now. You know, as you see, it starts at 16.5-foot setback on the side, goes to 18, and it will go to 19.5. So you're adding another foot times 10 feet. I don't know, you know, it's probably 12 to 15 square feet of, no, that's,
17 and a half feet of distance of that facade width. And how, I don't know what the height is.
I don't know if these plans show that information. Well,
Well, let's call it roughly 20 feet. So maybe 350 square feet of new nonconformity. That sound about right?
yeah, particularly if the house is good chunk of it, it's got to be, if the house, the volume of the house is 3,100 feet, it may be a little more, we didn't count the attic, whatever there is. Almost half of that is non-conforming already. So they're going to be adding another 400 feet, of which you know, a small amount is non-conforming, and the rest of it will be conforming because it's in the rear.
Mm-hmm.
So if you did some imaginary line where the you drew on what's known as the existing dwelling a line that shows the 30-foot front setback, and then another line showing the 20-foot setback, you'd have obviously some sort of a pork chop or L-shaped thing, but this isn't adding a lot to an existing nonconformity. You know, at best, it's adding about 15 or so feet,
Mm-hmm.
and it goes up, but fortunately, I don't think this is doing any harm given where it is and the very small amount of encroachment, additional encroachment, because most of that proposed addition conforms.
Right.
It's just a foot or so on average.
Yeah,
No,
it looks like it's 17.2 feet wide and probably about 20 feet high, so 350 square feet of non-conforming new facade, which is not much.
which is to round it off, call it 10%, I mean, I don't know, 3,100 of the square feet of the, yeah, I'm getting bogged down.
I don't have any other questions.
What about other members of the board on this one? Need to hear from some of our good colleagues. Lee Darst.
Lee's
Uh,
internet,
he's-
Lee's internet failed. She's trying to get back
Oh.
on.
Okay. Charlie, anything? Comments?
It's not a large addition in the non-conforming, but I hate to see us doing the calculations. I think the architect ought
Yeah.
to give us the figures, and so I would recommend continuing for hearing so we can get the additional information.
That's a very sensible thing. You understand what we'd like to see? We'd like to see facade, a two-dimensional, but we'd also like to see a volumetric calculation. How much volume are you adding in the setback?
Can I give it to you right now?
You know, no, you could do it between now and the next hearing, and we'd look at it, close it, and be done with it. I don't see personally a big problem, but the problem I have is probably what Charlie's alluding to. We have plans that have to be filed with the building department, and I'd like them to be accurate and have enough of the calculations on them, so that 5 years later, somebody isn't saying, "What, you know, what is this?"
Yeah, and I think if height wasn't on the plans, you know, height should be included with those calculations. And I mean, I'm just doing a quick measurement. It doesn't look like I know the site plan anyway doesn't have, it does have the abutting property, but not the structure. It looks like the closest structure is like 157 feet or so to the, I guess that'd be the south.
Yeah, the other thing our requirements specify is that neighboring properties be shown on a site plan, which are not shown in this plan. Because we don't know, I mean, again, we can know by visual observation, but is the neighboring house 5 feet from the lot line or 30 feet? I mean, I know this is an old
40.
neighborhood, but 40 feet? So maybe a little tune-up on the plan, on the dimensions would be useful.
So you'd like to see the neighboring property, the dimensions called out?
It
on
doesn't
the
have
plan?
to be, it can be in outline form. We just want to see the proximity or lack thereof. And if it can't fit by scale onto something like this, I mean, if it's 300 feet away, fine. You know,
A lot of times we're used to seeing the structure itself, you know, on the neighboring property, if it's within a reasonable enough distance.
Yeah, I think the reason the engineer didn't include it in the plan is because it was so far away.
And I did ask that, and that's what I was told, that I asked if they could be put on and they were too far away, the abutting property.
On both sides?
I believe so, because the other one is definitely down the marsh.
The other side is a town property.
Yeah, and you know, I think probably, yeah, the structure closest to the addition is about 157 feet away.
I don't know.
Calculation, so I mean,
The assessor's
if
map
it could
would
go
show-
on there, it wouldn't be a bad thing, because that's where the addition's gonna be, is fronting that side, you know, so it's, if you're gonna make some modifications and can have that on there, it will help.
You could shift it over. You don't need to show all the town of Cohasset. Just note that. I mean, and everything to the right or east, if you will. If you could add a little more there. If you still can't fit it in, then make a note and say that.
Well, I think the best we're going to be able to do on a scaled plan is to you know, call it out just as a dimension.
Okay. All right, and it's, you know, how far away is it from its lot, from the lot line? But, I mean, I think this is, I don't have any big problems with the design or proposition as is. But I would like to see more specificity.
So what the board would like to see from us is dimensions to the neighboring properties, as well as calling out heights on the elevations.
More of a height, facade, volume on the property here, and just locate the neighboring property. And if you can't fit it on by any reasonable scale, let us know how far away it is. And it's a building of 20 by 40 that's set back 800 feet. It isn't, but you know, something like that.
Well, 157 feet is going to be pretty hard to show on a scaled plan.
That's okay.
Yeah, I think your bigger issue is, yeah, we'll want to see the increase in facade within the non-conformity.
Yes, I got that.
So that's a must, you know.
And
Sure.
the percentage increase of non-conforming facade. Because you have a lot of existing non-conforming facade. And we'd like to know what percentage increase there is.
And if it's 157 feet to the neighboring house, I'd be happy with that as a note. As opposed to trying to rescale this thing down to a point where it really doesn't make any sense. Our concern when we ask for that information is when the house is 20 feet away or 30 feet away or 10 feet away.
Well, that's why at the beginning of the meeting, I tried to call out that we were well beyond 40 feet.
Right. So all we'd like that noted is on the plan. All right. Just let us know how far away the neighbor is.
Okay.
Okay, so I'd make a motion to continue the hearing until July 13th.
So Woody, can we?
Sorry.
Is there anybody in the
Oh
audience?
yeah, I'm rushing to judgment here. Jen?
No one in the Q&A. Let me just see if anyone's raising their hand. They are not. So I think you are good.
Okay, I would make a motion to continue this.
Second.
All right, moved and seconded. All in favor, Woody Chitikani.
Lee Darcey.
Charlie Higginson, aye.
4,
Dave McMorris, aye.
5, and
Yeah, Watkins, aye.
yeah. Okay, great, unanimous. All right, we now move to an appeal and a special permit, but they are somewhat related, but we'll hear the appeal first.
Woody,
Yeah,
can we have about a 5-minute break first?
sure.
Thank you.
Would everybody like a 5-minute break?
Yes.
Okay,
Yes, please.
all right. Jen, are you going to be our timekeeper?
You're driving us too hard, Woody.
Oh, God, I want to get home, but no, I'm home already.
A question for Jen. Is there any word on when we can finish with Zoom meetings?
Boy, she took advantage of the 5-minute break. You know, it's got to be just around the corner, Charlie, but it's a great question.
I have a hard time hearing some of the people.
Yeah, you kind of miss the informal give and take. I would have to believe it's right around the corner, but John Hallen, have you heard anything if you're still on? Cindy, have you heard anything?
Yeah,
Cindy.
I heard you. There's legislation that I have not heard if anything has happened today that is trying to enable municipalities to continue with hybrid meetings. Last I looked, which was not today, it had not been passed yet, but that's first and foremost on most municipal boards' list of things they care about, because otherwise Zoom meetings are coming to an end in June.
Okay, and this is a statewide as opposed to town by town?
Yes, because right now you're able to do it because the state law has been suspended in part the open meeting law to allow for remote participation.
Oh, that's, oh, yeah.
So you need state relief to continue it.
Thank you.
So when one goes, everybody goes, basically.
Yes.
Woody, while we're in hiatus, on the zoning bylaw amendments at the last town meeting, the moderator indicated that the zoning board had voted 3-0 in favor of them. I don't think we ever had such a vote.
We did, actually.
We did, yeah.
I haven't seen it in the minutes.
It was in the April minutes.
That was
And it-
before we had the changes.
You know, it was just the zoning bylaw working group. It wasn't all the zoning bylaws that were voted on by the zoning board. Only
There were three.
Right. Only the sunsetting of Article 16, the use variance, and the what was the third one, Woody?
Well, it
Oh,
changed the public-
land alteration.
land alteration, and then there was the public addition to Board of Health, which I
Right.
guess was not us, but
No, and then the other 5 were the held by the planning board hearings.
I bet you voted, Charlie. But it was so swift, you didn't know it was happening.
It was after Katie Dugan's presentation, and she just asked for those 3 that were being brought forth by the zoning bylaw working group.
Well, it was a fast town meeting.
I know.
That I liked. Okay, so we got a couple people still out. Jen is out.
I'm right here.
Oh, what am I saying? What am I thinking of? Charlie, Mike, the full board is here and John's here. So we could probably get going, eh?
Yes, I will. Going to promote Attorney Meixel.
Okay, so we're now going to open a continued a hearing on an appeal filed by Jill Brenner Meixel on behalf of her clients, the Wyndhams of 482 Jerusalem Road, appealing the building inspector's issuance of a building permit for a foundation under a porch, some basement footings, a front deck, and a kitchen room at 488 Jerusalem Road. So we will turn it over to Attorney Meixel. How do you pronounce your last name? I'm sorry.
Yeah, thank you.
You're muted.
You pronounce it correctly, which is very rare. So well done.
Okay.
And I would just ask Ms. Oram, John Pavanaro is here as well and will need to be promoted at some point if that is permissible.
Oh, I got
Sure.
Thank you. Good evening, members of the board. As you know, I represent John and Tracy Wyndham of 482 Jerusalem Road. We have appeared before the board on many occasions in connection with the construction project of the Wyndham's neighbor, Brian Stasko, at 488 Jerusalem Road, and 3 prior appeals related to this project, which happened over the course of last fall and were filed about a year ago. We're here tonight on my client's appeal of a building permit issued by Mr. Hallen on March 23rd, 2021, which allowed Mr. Stasko to perform certain work on the property without seeking a special permit. It's our position that the building permit's issuance is in derogation of the board's decisions issued in January 2021 and also of the board's decision issued in 2018 relating to the special permit on the addition. Those hearings and those decisions required Mr. Stasko to apply for a special permit for this work, and yet he didn't do so for this portion. He did so for another portion, which we're going to get to in a little while. Before I go on, I want to highlight one thing, which is that, which the board should take into consideration in determining the outcome of this matter. Essentially, this matter has been broken up into pieces. And it's sort of because of the way this proceeded. First, Mr. Stasko applied for a special permit to construct the addition, and he got that in 2018. And then he raised his original structure, and then he applied for separate building permits for both the addition and the reconstruction. And it's frankly caused a lot of confusion. As you may know, I've always taken the position that this is really one project. And we're sort of now back in that same situation here. It's our position that this building permit should be reversed, and Mr. Stasko should have to apply for a special permit on these matters, just like he is with respect to the other areas that we're going to get to a little later. So frankly, this is, in my mind, causing more confusion. But even separate from the confusion, there are certainly substantive reasons why the building permits issuance should be reversed. So our goal here is we're seeking the reversal of this building permit that was issued and requesting that Mr. Stasko be required to seek a special permit from this board. Before I get into the nuts and bolts of this appeal, I want to provide a brief overview of the course of events throughout this process. And this, just so you know, this relates also to the special permit hearing that's going to happen in a little while. I'm not going to repeat myself, but I thought it would be helpful for everybody to sort of get grounded as to how we got where we are right now. So, and I'm going to screen share, if that's okay, some pictures of the plan.
That would be great.
So in 2017, Mr. Stasko applied for a special permit to construct an addition to his then existing original structure. And I'm going to start by just one second. I'm going to show you all. Oop, I don't know what that is. I apologize.
There you are. Nope. Okay.
Can you all see my screen?
Yep.
Okay.
Well, I can. I don't know.
Everybody else? Okay.
Yes.
So I'm just going to show you this is where we started. So I'm going to show you a few pictures of the original house, as it were. I'm just going to scroll down just to get sort of a sense of what we're talking about here. So this is the original house, and this picture was taken from my client's property. Okay, so that's 2017. Mr. Stasko applies for a special permit to add an addition onto this house. Here's a couple more pictures that show, actually, whoop, I'm jumping ahead, what the house looked like in relation to, this front here is the Wyndham's house, and this back home there is Mr. Stasko's house. So you can see the comparison. Thereafter, actually I'm gonna keep the screen share because I'm gonna keep going with the screen share. In February of 2018, this board granted a special permit approving the addition, and stated in that decision, any changes other than minor field changes must be submitted to the Zoning Board of Appeals to ensure compliance with this decision. And I just want to bring up the 2017 plans so that you can sort of see what was approved. And I'm just scrolling for now. This is sort of to get a sense of, to situate ourselves. So this is the first floor plan.
The green, I assume, is no, isn't.
The green
is setback.
One second. The green is setback, correct. And this is the green in this photograph is the addition. So you'll see a few things to take note of. You'll see here the second floor balcony is just sort of a little nook. You'll see the grading here. There's no driveway. It is what it is. You'll see here there's no front porch. There's these pillars, but no porch. And of course, later we'll get to the roof, but just because we're here, you can see that the roof on the original structure is significantly lower, 2.5 feet lower than the roof on the addition.
Got it.
Okay, so that is, this is the approved 2017 plan. Almost a year later, actually, I'm going to unscreen share for a second. In January of 2019, so almost a year later, Mr. Stasko applied for a building permit for construction relating to the special permit. That building permit was issued in February of 2019, which at that time included some changes, non-minor changes to the special permit. In June of 2020, that was when Mr. Stasko decided to reconstruct his original house. And that was torn down. And he, in fact, began construction, or began to tear it down and began construction before the building permit was actually issued for the work. The construction, as we now know, didn't comply with the 2017 approved plans that were tied to the special permit. And in fact, also didn't comply with a reconstruction of a pre-existing structure in the same, same dimensions, same height, same, et cetera. So Mr. Stasko thereafter constructed both the addition and the reconstructed original house outside of the scope of what was permissible. In June of 2020, June 18th of 2020, Mr. Stasko applied for a building permit for the reconstruction of the original structure. About a week later, the building permit issued without any new plans for that original structure. And by that point, that was a building permit that we appealed. And that was sort of the point where, in my mind, all went awry. At that point in time, there was nothing on the grounds. There was no addition. There was no reconstruction yet. And frankly, it continues to go awry today, to this day. He began construction outside the scope of the 2017 approved plans and outside beyond what was permissible as of right with regard to the original reconstruction. On July 1st, Mr. Egan, the then building inspector, indicated that he was sort of reversing / clarifying his issuance of the building permit. And this is what he says, and I think this is important, so I'm going to read it. With respect to the issuance of the building permit, he said, this is to confirm the scope of work allowed at the above address under 2 previous building permits. With respect to the special permit, the permit issued on February 4th, 2019 is for and only for the work that was approved under the special permit issued by the ZBA on February 12th, 2018. It allows for the construction of an addition to the north side of what had been the existing structure based on the plans dated November 1st, 2017. And then he goes on to talk about the replacement of the original structure, indicating that that work is limited to the exact replacement of the structure on the same footprint with no increase in vertical section, et cetera, et cetera. Throughout 2020, construction continued in derogation of Mr. Egan's clarification regarding both the special permit work and the reconstruction of the original structure, which led to 3 appeals that were filed. The first appeal was the Wyndham's appeal on July 23rd, 2020 of the issuance of the building permit and the fact that there were no plans associated with that building permit. So it was very unclear to us what Mr. Stasko was actually going to build and if he was going to go outside the scope of what was permitted. Mr. Stasko also appealed the building commissioner's clarification of the building permit, which limited the reconstruction to the replacement of the original structure and to what was allowed under the 2018 special permit. And the third appeal was the Wyndham's appeal of the building commissioner's refusal to issue an enforcement order requiring Mr. Stasko to comply with the bylaw and the 2018 special permit. Thereafter, in September through December of 2020, we had many hearings on these appeals, and this board issued 3 decisions, I should say, on January 5th, 2021, essentially saying, and the decisions speak for themselves. However, they highlight that Mr. Stasko was required to comply with the 2018 special permit and seek further zoning relief for construction that deviated from those plans. Thereafter, at some point, the date of which I'm not exactly sure, but at some point after those decisions were issued, Mr. Hallen, who had become the building commissioner, issued a stop work order to Mr. Stasko and stated, among other things, as follows. He said, an application now needs to be submitted to the zoning board and relief must be sought and granted from the zoning board before additional construction takes place. He also said that an application to the planning board must be applied for regarding large home review. He further said that, quote, proposed pier system foundation has been changed to full concrete wall without approval. The structural framing has been removed below the porch without approval. And he directed that, quote, zoning relief is now needed from the Zoning Board of Appeals for the backyard foundation. And this is located at Exhibit G to my submission. I'm going to go back to screen share. And I showed you those original pictures of the house and then the original structure and the original structure compared with, you know, from the vantage point of the Wyndhams. And now I'm going to show you, so in or around the time of the last hearings we had, it was sometime in the winter of 2020. This is what the house, let me go up here. This is what the house looked like at that point in time. So the house was largely complete. And this is the viewpoint from the Wyndham's deck. Now I'm just going to show you what it looks like today, or I think these pictures were taken a few days ago. This is the structure as it stands today. And you can see a lot of digging. This is from Linden Road, the Linden Road side of the property. And here you can see, and this will be addressed later, you can see the work on the grade with the new driveway and work that's being done in the street. And if we look at this picture, you can really tell this area that I am circling, that's the second story porch that was not approved as part of the 2017 special permit, nor was any of this area. And if we just jump back real quick to the plan, you can see the extent to which this area was changed. Okay. So to get to why we're here today, on March 4th of 2021, Mr. Stasko applied for a building permit relating to the foundation under the front porch, among some other areas. One of the areas that substantially deviated from the 2017 plans, and which this board required Mr. Stasko to seek permission by way of a special permit. And that's located at Exhibit H in my submission. The building commissioner, Mr. Hallen, thereafter on March 23rd, 2021, issued the building permit for the foundation under front porch, basement footings, front deck, and the kitchen room. And in issuing the permit, Mr. Hallen marked up the plans, allowing Mr. Stasko to perform work in certain areas relating to the 2018 special permit, despite that Mr. Stasko had never obtained zoning relief from this board as required by the 2018 special permit and the 2021 decisions. And then in May of 2021, just recently, as you all know, Mr. Stasko applied for a special permit relating to certain work on the original structure. And as we'll discuss later, from our perspective, the special permit application has many problems and is very confusing on a number of fronts, but I'm not going to get into that at this moment. So that's some background. Now to the merits of this appeal. From our perspective, the issuance of the building permit was completely improper for a host of reasons. The building permit directly contradicts the ZBA's prior decisions in 2021 and 2018 when the special permit was issued, and I'm going to briefly address both. First, the building permit directly conflicts with the board's January 2021 decisions. And in particular, the board confirmed in those decisions that the building permit, the board confirmed the building permit only to the extent it authorizes work allowed as of right under the bylaw, but did not authorize any, and this is a quote, any additional work until and unless Ryan Stasko files for and receives a special permit modifying the 2018 special permit. Regarding the Wyndham's appeal of the building commissioner's refusal to issue an enforcement order requiring compliance with the 2018 special permit, the board directed, quote, the building inspector to issue a cease and desist order at 488 Jerusalem Road. The order limits activities to any activities that comply with the 2018 special permit issued by the ZBA, work as a matter of right, and any weatherproofing necessary to protect the structure for the winter. The decision addressed, among other things, deviations in Stasko's new plans from the 2017 approved plans, including changes in the foundation from sonotubes to a poured foundation and expanded deck with a roof. The decision specifically provided that Mr. Stasko should, quote, file a new special permit application with the board to address construction and other issues that have arisen to fall outside of what is allowed as of right and the 2018 special permit granted by the ZBA. The board members agreed to this process. Stasko and his counsel, quote, recognize there are issues that need to be addressed and they are willing to apply for a modification to the 2018 special permit. Quote, after much discussion, it was agreed that Attorney DeLisi would file for one permit addressing all issues discussed and that any construction outside of that would cease. And that goes to my point earlier about now we're breaking this up. I don't think it should be broken up anyways. I think all of this work requires an application for a special permit, but it's just confusing the whole matter, which is already confusing based on sort of the breaking up of the project that happened in the first instance by getting a building permit that shouldn't have been requested and then going to get a special permit. Secondly, the 2021 decision was reached. You got to that point because the 2018 special permit specifically did not allow for this additional work. The deviations from the scope of the 2018 special permit and the work sought through this building permit are significant and not minor. There are clear reasons why the 2018 special permit and the 2021 decisions require Mr. Stasko to seek further zoning relief to proceed with this work, which deviates from the 2018 special permit. The work significantly expands the scope of the 2018 special permit. And I know we talked about this probably ad nauseum at all the other hearings. So I'm being a bit repetitive, but now we're back where we are now. The scope of these changes is explicitly detailed in Exhibit K to my filing, which were blue cross-hatched plans that we had submitted at your request, showing and comparing the plans submitted by Mr. Stasko in 2020 with those approved in 2017. The building permit authorizes Mr. Stasko's construction of an expanded foundation, which was the subject, as I just said, of the 2021 decisions, without a special permit. And it includes, in fact, work within the front building setback, which requires a special permit. And I just want to say that the issuance of the building permit even deviates from the building commissioner's own directive in his stop work order, which I read a moment ago, which specifically states that zoning relief is now needed from the Zoning Board of Appeals for the backyard foundation, and highlights that a proposed pier system foundation has been changed to full concrete wall without approval. The structural framing has been removed below porch without approval. And I just want to address briefly an argument that is going to come up in the special permit hearing. to the extent that Mr. Stasko is arguing now that the 30-foot front setback somehow does not apply is simply untenable. This 30-foot front setback has been discussed at every hearing that I've attended, and there's never been any other front setback that has been addressed, either by myself or that I recall from Mr. DeLisi. So any argument that a 30-foot front setback does not apply just simply doesn't work. So I think what we're going to hear in the special permit hearing is that Mr. Stasko is now apparently taking the position that this 30-foot front setback does not apply, and that instead his front setback only has to be 7.4 feet because of the average setback exception. And I'll just say that Mr. Stasko really puts himself in a pickle here, because he built a structure. He did so defying the bylaws, building portions of the property that were never allowed and that were non-conforming and needed permission. And now that the building's, you saw it, it's fully constructed, he doesn't want to have to knock portions down, and he's trying to sort of pull a magic solution out of a hat. So now he's saying, oh, look at my neighbor, they're 7.4 feet away, and so I'm just going to use that magic number and see if it flies. And again, I've never heard this reference before. And even if I had heard it referenced before, the average setback exception is just wrong and can't be based on the setback of one neighbor. It's an average. It simply just cannot hold. So in addition to the fact that I would argue precedent has been set with respect to the 30-foot front setback applying, 7.4 feet is not an average. And it's unfathomable and I think unprecedented to come up with an average based on one house. An average is an average, and it simply shouldn't apply here. So to the extent that that's the rationale for granting the building permit here, or frankly for any other argument that's going to be raised in the special permit hearing, that simply should not be, that it's simply untenable and unprecedented, in fact. In closing, Mr. Stasko's conduct here conflicts with the clear intentions of the town's zoning regulations and this board's decision. Not only is the reversal of the building permit's issuance critical, given that it violates the applicable bylaw and this board's prior decisions, but allowing this work to proceed without requiring further zoning relief really undermines the intentions and purposes behind the town's zoning requirements. As we've talked about on many occasions, and you all probably know my position by now, but it's quite shocking, in fact, that we're sitting here today. A year ago, there was nothing on the ground. There was nothing. And now we have this structure, some of which is unpermitted and was not, the protocol and the processes and the bylaws that were put in place for a reason were not followed. So now we're in a situation where Mr. Stasko, like I said before, he doesn't want to have to tear anything down. And on several occasions, I recall Chair Chittick, saying on the record that, you can beg for forgiveness later, but you're doing this at your own risk. You're doing this at your own risk. He knew what he was doing. He knew that we had raised an issue from the very, very beginning. This is not something that came out of thin air. And yet he continued to do what he did. And now he's in a position where he has this huge house that is, again, I'm just going to do one more screen share and then I will stop talking, I promise. But you look at this original house here. This is what was there before. And again, because we did this piecemeal, we never had a special permit process where my clients could vet their concerns regarding this, what has become now this. So it's been done piecemeal. And I think that's by design. I think it's absolutely by design, because I think Mr. Stasko knows that if he had come in here and gone from this to this, particularly given all the nonconformities, he would have had some real problems. So let's just do it piecemeal. Let's just do it piecemeal. Let's drag this out. Again, we were in there on these hearings in December. Now we're in June. And it took him until a week ago, I only got the special permit papers a week ago, to file his special permit application. Really no reason at this point why he can't just put it all in there. Not only should it be in there, but that would be the proper thing to do given where we are now, given where we started here and where we've ended up with here. It's just not appropriate, and it totally belies the purposes and intents of the bylaws. And for all of those reasons, it's my position that the building permit should be reversed. And I would just say that I know I talked for a long time, and I appreciate your divulging me and allowing me to do so. But to the extent Mr. Cavanaro has anything to add from an engineering perspective, I wanted to give him an opportunity, although he will have even more to add with respect to the special permit. Thank you very much.
I think for the most part, Jill, that the technical matters through the special permit. I can just very quickly go through in terms of the plans that were previously presented. We want to focus on still the building height and the difficulties it is to determine between what is the existing average grade and how height is being measured from an architectural standpoint to which midpoint of which roof. And also we'll get into more detail on the front yard setback from Linden Drive. Thank you.
Okay, I'm wondering if it's appropriate to hear from John Hallen first, and then we can start asking some questions and hear from the other side. But John, this, if you don't feel that this is an appropriate time for you to shed some light on this, say so, but otherwise I'd like your perspective.
Sure, I'd be happy to. Thank you, Mr. Chair. First of all, I guess it kind of highlighted some of what was said. We'll go back to the stop work order, which was issued, and I did have 7 points in the stop work order, some of which were addressed in the application for the permit. The first one being, the change in plans of height there, which is going to be a zoning issue, which will be before you next. The attic height, again, another zoning issue, which will be before the board. And then the proposed pier system foundation change from a full concrete wall to without approval, not meaning zoning board approval, but building approval with the structure of it. And that was a system change, not necessarily a zoning change, in my opinion. That they addressed in the permit application. The garage door was again another change, structural, that we needed to address for the permit. So when they did apply for the permit, we were able at that point to send it to the fire department for their review and approval of what we needed to put inside the garage for smoke and heat sensors. And then also at that same time, we looked into the stormwater drainage system and approval. And in the original calculations, they did include that area in their calculations. So that was, part of the original stormwater bylaw approval. So we got that squared away.
When you say the original bylaw approval, you mean back in 2018 when we?
Yeah, I think when they went in front of conservation, they had that square footage of where the pier system is as part of this stormwater work.
Okay.
So that again, that was one of my questions that I had with the original stop work order. The driveway addition at the upper garage bay, that's going to be again, we haven't approved that yet. That was part of the permit, but that's going to be a public works and review either by Kyle or Brian Joyce. So that's a different area. Then the other number 6 that I questioned was the placement. There was a front porch area that wasn't clear whether it was heated or unheated. So that was
more of that.
More gin and tonic?
Yep. Go ahead.
So we reviewed that. That was in the no work area on the permit, and it's been later discussed that again, that is an unheated area, so would not count as part of the large home review. square footage. And again, when I said the zoning relief needed for the from the appeal board for the backyard, they had designated, if you remember prior, we had a corner lot, so we have 2 front yards, and then it was listed as 2 side yards, but we needed a backyard. So the applicant, I believe, had gone through the process of designating a backyard setback. So that, that was the area that they would going to have to go back to the zoning board for relief with, to explain that. And again, they were put on notice, if that's the right word, that they're approaching the area of large home review with the attic addition and that space. So they had to, again, come forth with that information at a later date. So the permit was issued for a very specific area to address certain amount of problems that we had if we're looking from the Linden Drive side on the left-hand side of the property. That's why we took kind of great care in, reviewing it with the fire department, talking to the conservation agent at the time and checking with the storm water, and then going back and highlighting the areas that were allowed to be worked in and the areas that weren't allowed to be worked in, with the understanding that this was a phased permit and that before any other work could be done outside of this permit, that it was understood that they had to go back to the zoning board, and they agreed to that. And that's kind of where we had issued and why we had issued the building permit.
Has work been ongoing before they've been before the zoning board?
Well, since we put the
help needed zoning board approval continued without that approval?
The area that they required zoning board approval, there has been no work. I have been out to the site probably a half dozen times anyway. They have started work in the area that they were issued the permit for.
Okay, and some of these points you said in your stop work order were really not zoning issues. A couple of them were not.
Right, and that was where the permit was issued for the that I had issued. We're addressing the other issues, not the zoning issues. And again, the question of average front setbacks did come up, and like we discussed with them, I realized that one of the neighbors is close 7 foot, 7'4" but we explained to them that there were 2 data points that needed to be obtained for the average setback. And the second data point, if it wasn't anything in place, would be the normal setback of 30 feet. So that's they were instructed that would be where
are they not in compliance with that?
I believe they are on the portion that we issued the permit for.
Okay. It looks like a lot of work has gone on, even in the last few months. But board, I'd like everybody to sort of.
There's a lot of questions because there's been a lot. Again, there has been, as you well know, there has been 4 or 5 permits issued and different pieces here. And again, one of the reasons we initially came to the stop work order was to start to address some of those issues. And I think the phased in second permit did address some of those issues, leaving some of the larger issues to be addressed in, again, your next application.
Okay, do members of the board have questions of John or Jill at this point, or should we hear from Jeff DeLisi and his team? What's the wish of the board?
I'd like to hear from Mr. DeLisi.
Anybody have a contrary point of view at this point? I mean, silence isn't helping anything. Just,
I don't think I have any questions just yet.
okay, well, anybody else?
I don't have any questions at this point. I would like to hear from Attorney DeLisi.
Okay, let's turn it over to Jeff.
Thank you. Thank you, Chairman Sheddick, members of the board. For the record, Jeff DeLisi representing Mr. Stasko. He's on the call this evening as well. And I think it might make sense, Jen, just to promote him into the call should there need to have him address any particular issues. I'm going to try and keep it brief because we have a whole separate hearing after this. After your 2021, January 5th, 2021 decisions on the 3 appeals from last year, we received the letter from Mr. Hallen. I believe it was dated the 20th or thereabouts of the month of January. And the way I viewed the letter was that John was attempting to quantify the issues as to what he saw to be matters that needed to be addressed from his perspective. And that letter kind of kicked off a bunch of conversations with John as to what on this list of these 7 enumerated items would you like us to address now? And what items would you like us to address through the special permit process? And he identified very specifically things that he wanted to see us do in connection with filing a building permit application to kind of address the issues that he saw to be, I think, what he described tonight as process issues. And so from our perspective, we kind of rolled up our sleeves and began to do that. Just as an aside point, I'm not going to get into disputing the characterizations and the history that Attorney Maxwell has put forward. Obviously, we have a different vantage point based on communications and conversations with Mr. Egan and the permits that issued and so forth. In this particular case, one thing that the applicant's attorney did not mention was that there was a letter issued by Mr. Hallen in March, which kind of confirmed what we'd addressed in the building permit that was issued in March and what is left to be addressed through the special permit process. So from our perspective, we're doing what the town is asking us to do and apply for a permit to legitimize those issues and address those issues that could be addressed outside of zoning. I was planning on getting into the average setback question as part of the next hearing, but I might as well use that airtime here. It was me who looked at these plans and realized that there probably is an average setback issue that nobody had kind of caught before. And so we did our diligence. The house, for members of the board that might not be aware, the average setback exception to the front yard is set forth in the 3rd note behind the table of area regulations. And essentially what that note says is that there can be an exception to the required front yard setback from any street or way for the average of the buildings on either side of the dwelling within 200 feet, basically. And if no building is within 200 feet on one side, the data point would be 30 feet. So what we did was we did a Mass GIS kind of approximation of the house at number 2 Linden, which is to the south. And what our site plan for the special permit application shows is we have an average setback of 7.4 feet. Since then, we came to understand some information that would indicate that that number actually could be slightly less. And so we asked our engineers to do a field survey, and understanding that the special permit hearing, at least in this that's about to come up, would likely get continued. We'll be providing, I can send that over tomorrow, but that field survey did come in tonight, and they determined that it's that number 2 Linden is actually 6.4 feet. So understanding that John Hallen has indicated to us that you can't just use one building as in an average setback calculation. We added 30 feet for the other data point and then divided it by 2. And our calculation is that the average setback would be 18.2 feet in this circumstance. So I think that that's relevant for purposes of the building permit appeal process, because much is being made of, in particular, the setback of the covered porch and the foundation underneath the covered porch. Those setbacks exceed 18.2 feet. And so under section 8.7A of your bylaw, it would appear as if John was correct to issue the building permit with respect to the front yard setback issues, because that's allowed to be the case when the work is conforming to the setback requirements. That's how I read it. So those would be my responses. I think the next special permit application in any event has these items kind of subsumed into it, if you would. It was not just an application to deal with the reconstruction project. It was an application to take into account the differences between the 2018 special permit and what was constructed with respect to the addition on the one hand, and on the other hand, the differences between the reconstruction permit in 2020 and what was actually constructed. And I'll just take a moment, since the issue of height was raised and et cetera, that particular issue of height, and we'll be providing, we have facade and area calculations and volume calculations that our architect has provided. But those calculations have what appears to be a very de minimis amount of increase in the setback of the facade, meaning increase in height really only of that setback area. I think of like 3% or something to that effect. So, but those are issues I know that we'll address in the next meeting. And that's my response.
Okay, board members. Jill, would you like to shed a little more light, having heard both John's testimony and Jeff's observations?
Sure. I'd be happy to respond. So a couple things. Number one, in my mind, all zoning issues raised regarding the addition need to be dealt with in a special permit, which should be heard by all of you. And I know, and I appreciate Mr. Hallen went through the points 1 through 7, but if you look at Exhibit J to my submission, which is the marked up, and I don't think I actually have it to screen share, so I apologize, but it's Mr. Hallen's marked up plan relating to what work was allowed and what work isn't allowed. And the plan essentially circles the addition on each page, the areas of the addition or portions of the areas of the addition as work areas, and areas of the original reconstruction as non-work areas. And the building permit itself indicates that it is addressing seeking permission regarding the foundation under the front porch basement. And in my mind, this is just a clear zoning issue, which requires approval through a special permit from all of you because it intrudes into the front setback. And with regard to the front setback, I still take the position that it's 30 feet. That's what we've always used. This average setback exception has literally just come up at the final hour. And I think that 30 foot is the precedent that's been set in this case. And I think that review and approval of this work, the significant work that was done under the foundation, and I mean, I could bring up the pictures again, but it's significant. This is no small piece of work. Requires your review and approval as part of a special permit process and not as part of as of right approval, which it essentially is. And I'll make one final note, which is this addition and this structure keeps getting bigger and bigger and bigger and bigger. And again, I'll go back to what I said before. If we had been before you in 2018, knowing that this is what we were going to be dealing with, this would have been a whole separate analysis, and you all would have looked at and reviewed carefully the portions of the addition, which is really just a complete reconstruction of the whole house plus a big addition. The foundation under the front porch, the basement footings, the front deck, and the kitchen room. You would have reviewed that very carefully in determining whether and the extent to which a special permit would be granted. And you would have reviewed it before anything was even on the ground. So I don't see how Mr. Stasko now gets essentially sort of a free pass to go forward. And again, keep adding a little here, a little there, a lot here, a lot there. We do the driveway today, we do the front porch tomorrow. And it's crazy. And if you look at the pictures that I showed you, just the vast difference in the structure, the volume, the massing, the height, everything is substantial. And the way this process has gone down is just not appropriate. And at a very minimum, Mr. Stasko should have to come to you all through a special permit process to get approval. And that's in fact what you required in your decisions. So we can go back now and, I appreciate if Mr. Howland's trying to work with Mr. Stasko, but I mean, frankly, it's too late for that part. We decided that he needed to come to you on this. And now we shouldn't be backtracking, particularly given the course of events that this has taken, which I think is fairly egregious. This isn't how the system works. You guys don't sit here once a month to go back and forth on things that should have been done right the first time. So
I would agree, but on the other hand, I mean, 2 points. One, it isn't that we have to, I don't know who the we is. We, as the zoning board, had agreed to allow Mr. Stasko to go forward with the approved 2018 plans. Stop, nothing more, nothing less, because we had approved that 2 years earlier. So we can get into whether there's been sort of a construction creep or not, and whether that is being covered in the special permit request coming up or not. But it's been pretty clear to me, and I think the zoning board, that our approval was granted back 3 years ago, more or less, and is still valid. I don't see any reason to rescind that. Secondly, very small point, that note 3 has been in our bylaws since God knows when. It's nothing that just has been a surprise or crept in there. It's been applied sometimes, as Matt knows, back in Summer Street, one of our favorite houses, but it's been there. And I think the applicant has every right to apply the bylaws as written or take advantage of approvals or by right. But that doesn't excuse all that's gone on. I'm just saying there are a couple of little picky points there.
Just had one quick question for as far as clarification on this, because Mr. Howland brought up the stormwater permit, and that's relative to sort of the progression of the plans and our understanding of what was approved. So my question has the stormwater permit plan of record been revised to his opinion?
If I'm allowed to answer?
You'll have to, I can't.
Sure. Sure. What we did specifically was I asked the former agent to review that area, and if that was part of the calculations in the stormwater plan, in which he did, and he said it was. So again, that's the, I would say the front porch area there. So that was included. He didn't review the whole plan at this point, but the portion that was the permit was issued for was calculated. You know, if more needs to be done, we'll look at it. But he did review that and let me know that it was approved.
Okay.
And calculated.
If I could just really quickly go through 3 quick plans and spend very little time, and we'll probably get into more detail.
Yeah, it's getting on. I don't want to short circuit this.
Yeah, just real quick, if that's okay.
Yeah, go ahead.
I'm going to pull up, this is the approved stormwater permit plan for the property. And this actually was a helpful plan to us because the other 2 site plans that have been submitted, they all reference a 2009 survey, which is where this all began. And then it was changed in 2017, and then it continues to change right up to tonight, I guess. We have new setbacks that we'll have to look at in future hearings. So the important thing, this is the record stormwater permit plan for the property. And it's important to note they make reference again to the previous Merrill plans, and the topography goes back to 2009. That's where all of the average grade elevations are based on for this property. But the most important thing here is what's happening in the front area, because in this approved plan, as far as grading is concerned, a few things to note. One is the location of where they had their proposed infiltration system, which was actually about a 2-foot fill in this area to enable them to provide adequate infiltration for the roof runoff so that they had a separation to the water table. They had to elevate the grade here by about 2 feet. This is contour 34. This is proposed contour 36. So that was an elevation in grade. Also note back here, there was a retaining wall, but there's no other impervious surface back here, nor is there any other impervious surface all along this back area. If we go to today, we look at what's out here now. We have a foundation here. We have a little concrete sidewalk back here. So there's been substantial change from that approved stormwater plan. Additionally, things just have sort of popped up over the years as well. We'll get into average grade at the next hearing. We'll get into that more detail. But this concrete pad showed up in the 2017 plan, although it wasn't on the stormwater record plan, but then in the latest plan, it turned into a foundation. So and we still don't see the concrete sidewalk in the back, but the point is, and more importantly, is what's happening in this latest plan is that we have a big cut in this front area to account for this new structure, this new driveway coming in. We had on the approved stormwater plan, we had a retaining wall along the right of way that went to the existing driveway. And now we have this has been truncated, this work in the public way, and we're proposing new retaining walls within the public way. This is the property line up here. So this is all in the public right of way. But more importantly, this grade has been so substantially changed. We don't know what the proposed grade is, other than we see that there's a slab elevation here that says 34 feet. But that's a lot different than grazing the grade to 36 feet in the same area. So a lot of changes. It's difficult to keep track of. And really the big question here is, where is the starting point? Are we actually beginning in 2009 to establish grade, or are we going to talk at the next hearing about, is this the beginning? Do we start to analyze average grade today, or do we roll it back 10 years and start?
And where does the Concom come out in this?
Where do they come
Aren't
out
they,
of?
aren't they concerned about stormwater?
Well, that's why I was curious if that plan has been updated since.
I think, Woody, to answer that, I think the second permit that you're going to see next is going to be more detailed, and then we could get some direction as
Okay.
far as what's added on there. Again, the original permit was kind of just, we didn't have any retaining walls permitted in that or any of the other exterior part at this point. It was just kind of focusing on the building portion of it.
What would be the best procedure at this point in time? We have an appeal in front of us, but a special permit, and the appeal is what, to cease and desist all activity? Jill, is that what your appeal basically says?
Correct. The repeal is to reverse the issuance of the building permit and not permit Mr. Stasko to engage in building activities in the areas that were approved.
Until or unless a special permit is granted?
Correct, except I should say that, correct, although I should say that this last period, the last 5 months or so have gone by and we've sort of just been waiting to see what Mr. Stasko does. So I think it would be fair to put some sort of time limitation, because again, the building is there. The substantial detriment is there to my clients. It's there. So I don't want this to sit there forever without a resolution. And so that would be my suggestion, is to, or my request would be to reverse the issuance of the building permit, forbid Mr. Stasko from doing any construction in those areas that were initially allowed, and requiring him to, if he's going to file a special permit on those areas, to do so in short order and not in 6 months.
Woody, you mind if I jump in on something?
Sure.
Thank you. Just a couple points is, number one, we have the right to build what you permitted in 2018. We have the right to build pursuant to the reconstruction, which was not some grand plan to do this in pieces. It was actually a significant problem that was discovered as we began to do the work for the addition. And Bob came out, he agreed it needed to come down. He allowed us to demolish and commence that work pending him to issue that permit. And that has occurred. With respect to the average grade question, my understanding is that that issue was addressed at the hearing in 2018 specifically, and it was determined to be whatever it is indicated to be on that plan, which is the same number that's on this plan. So we can only go by the grade that was determined to be the case at that time. And I do believe that we had some conversations about that last year when the appeals occurred and you requested us to provide you with information and we had provided it. I thought the average grade question, which was at the time advanced for not for stormwater purposes, but for calculation of height, was determined, because I think I recall that Ryan's architect was taking an average grade in the approximate area of what we call the bump out addition on the rear that never got constructed. And you had insisted that what we need to do is take it around the entire house, which we then provided that calculation, which was based on the number disputed and agreed upon in 2018 during the special permit process. And
it seems to me, I don't know when the appeal period ends, when we have to render a decision, but I think it's premature to close the appeal hearing. We haven't even heard the special permit hearing, and it's getting late, and I'm not going to go beyond 11.
I defer to you. I think
we can be mid-sentence, and I'm calling a halt. Jen.
So on that matter, so I did Are you there?
Yeah, yeah,
Okay, I did look, so
sorry.
we, the appeal was filed on April 16th. So we're about halfway through the appeal period, but I would put in request to Attorney Meixel to give us an extension, and I could work offline with that. Another option to consider is, it is late, we still have a lot of business. We could decide what you need to go forward on this hearing, continue to a date certain, which could include adding a meeting.
I think, I don't know, let me first turn to Dave as my trusted vice chair. I'd rather get a special meeting to deal with this one rather than put it off into the middle of July when we'll have 4 more hearings and everything else going on.
Yeah, I think we still have a lot of work to do on 147 South Main too.
Yeah, exactly.
Right. So if I could, if I may, before I can give some dates for everybody to consider. If Tuesdays work well, we could look at or Mondays or Tuesdays, we could do the 7th or the 8th or the 14th or the 15th. I know it's a lot of wrangling, but if we do the board's availability first and then make sure that
Does the 7th or 8th give you enough time to advertise and all? 48 hours or?
Oh, I don't need to advertise. We'll just post. So we would just continue everything. But particularly we would focus on this property. And that way it doesn't have to go a full month and it'll go past 11 and get everybody moving.
If, life is good and we had some extra time, why don't we talk a little offline as to whether we could shoehorn anything in 147 in, but I think
Right.
this we've got to deal with.
Right. I think giving this particular property a full meeting makes sense, plus anything else that we could continue that you feel
So
comfortable.
how does the board feel about either next week or the following? Cindy? You're muted.
Muted.
I am not here the 7th and the 8th. But that doesn't mean you can't have your meeting without me, if it works for everyone else.
Both those weeks work for me at this point.
Woody,
not
I'm
available.
unavailable on the 14th.
I'm sorry?
I'm unavailable on the 14th.
Okay, Jeff's not available. How about other
Okay.
people?
I'm not available on the 8th.
Okay, 8th and 14th.
I think I'm good for any of those dates, Woody.
What about Tuesday, the 15th? Let's work our way back.
I'm fine on that day.
All right, that's because it is a little tough to schedule a meeting, 6 or 7 days.
Right.
Hence, I would recommend that we have a meeting on the 15th to deal with this in full, but
Everybody,
go ahead.
Attorney Meixel, does that work for you?
That works for me. I'd like to check Mr. Kavanaugh's availability as well, please.
Yes.
Okay. Now we have the option to either start the special permit process or really just, I don't know whether 15 or 20 minutes can do it justice at all. And would we be better off continuing that until the 15th and having a full discussion?
And Woody, do you mind if I jump in on that one too?
A bit.
Okay, great. The way I was planning on addressing this meeting tonight was basically mostly just kind of an explanation linguistically of what we're attempting to do. I fully figured that you were going to try to continue the hearing and we'd be kind of well into the evening. So I was thinking maybe I can just kind of linguistically give you where we're at with it and maybe just get some initial feedback if you're looking for any additional information.
Okay, well, first, I think we should continue the appeal that's in front of us. I would recommend, sorry, Dave.
I have a question on the appeal issue first. And I guess I'm not really clear. I know there's been a building permit issued for some work, and looking at the markups, I see that there's things circled that say work area, no work areas. The fact that a building permit is issued and an area is circled for work area, is the work that the building permit covers limited to what if it's in that 2018 special permit, is it limited to the work that we approved in the section in the 2018 special permit? Or is the building permit good?
Is
for
it,
the
is it open
changes
season?
that they-
You can do anything you want within the work area.
Right, and do, changed work from what the original permit was, or?
Let's ask John, what's your understanding?
Yeah, I'm off mute now. The permit area was broken down to the plans that were submitted to me, and I just isolated the area that I thought were a matter of right, and then the area that I knew needed zoning relief, I put a yellow line through and said no work.
Okay, and as a matter of right, are you considering there are changes in the areas as a matter of right from the plans that we approved in 2018? And is that because it's conforming, or is it because they're minor field changes, or what?
I think some of them were because they are conforming, and the other portion of it, they weren't significant, in my opinion.
Okay.
Okay. Well, all right, why don't we, I would like to continue the appeal piece. And then Jeff, and then we could open the hearing, and if you want to give us 5 minutes, but be merciful. Okay, and help us understand, because we'll all be able to get into this with fresher minds and more time ahead of us in 2 weeks. So may I'm going to make a motion to continue the appeal before us until Tuesday, June 15th.
Second,
All right, moved and seconded. All in favor, Woody Chidick, aye.
Lee Darst, aye.
Dave McMorris, aye.
Matt Watkins, aye.
Mike Dickey, aye.
Okay, and Charlie Higginson, if you unmute, that would be great. Otherwise, I'm getting a 5-zip. Okay, and I would now like to open the special permit hearing. Attorney Jeff DeLisi will take a few minutes to talk about the special permit that we will be dealing with in 2 weeks' time.
Okay, thank you. Thank you, Mr. Chair. The board is familiar with the property. The property is located at the corner of Jerusalem Road, Linden Drive. It's in the RB zoning district. The lot itself has some nonconformities, and that's with respect to lot area. We have a little more than 17,000 square feet in a 35,000 square foot zone, and lot width we have on Jerusalem Road being 70 feet in a 125 foot zone. As was debated and resolved in the zoning hearings last year for the bylaw, since this is a corner lot, it must have 2 front yards, 1 rear yard, and 1 side yard setback. And at the hearings last winter, the board expressed the consensus that the applicant can choose which property line would be the rear yard. And in this case, since the property has an address of Jerusalem Road, amongst other reasons, the applicant has chosen the rear yard to be the southerly property line, which is the property line that's shared with the lot at 2 Linden Drive, which is opposite Jerusalem Road. Mr. Stasko's dwelling itself was pre-existing non-conforming in a few respects. Front yard setback, you can see the garage there is pretty much right on the property line. And then rear setback to the south, which is the 2 Linden Drive property line, and that's at 4.6 feet in the 30-foot zone. And side setback to the east, which is the property share with the Wyndhams at 482 Jerusalem, which is 15.1 feet in a 20-foot zone. So we went through the history, 2018 special permit, 2019 building permit plans, which were approved by Bob Egan, differed from the special permit plans in a few respects. Of adding a front dormer to the front of the house along Linden, covering the porch on the north side of the house in the area of the addition, constructing the concrete foundation under that area instead of sonotubes, providing also for what we called at the time a rear bump out foundation and addition, which we wrongly believed that we could construct under the side rear yard setback exception that says that structures off of those side and rear yards could be as close to 15 feet so long as they're limited to 15 feet in height. So those were the differences in the 2019 building permit plans versus 2018 special permit plans. Then in 2020, as we discovered the damage to the foundation, Bob Egan issued another permit for reconstruction as of right. And the net of the 2020 appeals is that essentially we need to file a special permit application for the differences, right? That was the whole point there of that exercise. There have been some noteworthy developments that have occurred since January 5th and the date that those decisions were filed. First, you have the quote unquote cease and desist letter from John enumerating the 7 items. Second, we work with John, as I indicated, to address some of those issues, which led to a second letter dated March 22nd. I don't know if it's in your file from John, which was the day prior to the issuance of the building permit. And in that correspondence, he basically said, you satisfied item 3, you satisfied item 4, you satisfied item 6. You still have to go for items 1, 2, 5, and 7. And so the third substantial development was this issue of the average front yard setback, which I explained to you, and you'll have in your packet for the next hearing. We now have a field survey from Doug Auberg of Merrill Engineering that indicates that 2 Linden Drive is setback 6.4 feet. When you take the average of that with 30 feet on the other side of the building, we come to 18.2 feet. And that's what establishes the front yard setback, okay? The other issue that's a significant development, we understand that the Wyndhams had really expressed a strong issue with respect to this concept of the bump out addition on the rear of the house, which is actually the shared side and rear line. We've decided to forego that entirely so that there's at least the privacy issue that was articulated with respect to that from the Wyndhams. We've just decided to scrap it for now. So that brings us down to why we're here. Section 8.7a, which I indicated allows alterations to non-conforming dwellings, so long as the work complies in all respect with area regulations other than required lot area. 8.7b, which you guys are all aware of, defining required under 48 section 6 that allows a special permit to be issued, which is that the extension or intensification of the nonconformity is not substantially more detrimental to the neighborhood. And then we have section 8.9 as an operative section, which allows the reconstruction as of right within the vertical plane on the exterior dimensions, and which does not increase nonconformities, which I think is an issue that we're going to address in a bit. So when we take the issues, front dormer on Linden Drive, 20 feet 6 inches, it exceeds 18.
Are you going to go through the detail of special permit? I mean, I'd like to cover most of this in 2 weeks' time. I think you've teed it up.
I only have about 1 or 2 more minutes left, Woody.
Okay, go ahead. Go ahead.
Front yard dormer exceeds 18.2 feet off of Linden. Same with the covered porch. Same with the foundation below. That basically brings us to, we've eliminated the rear bump out. That brings us to the height, really basically the amount of the difference in height that's within the non-conforming setback area, essentially. And you have calculations in front of you that express that is about a 3% increase. We also, and I think it is noteworthy in this session to just kind of get out there, that with our special permit application, we filed an alternative plan, which we've discussed in great length with John, John believes is something that can be done as of right, which should the board decide that the increase of 3% is substantially more detrimental to the neighborhood, then we probably would create a situation where there's a flat roof, which actually reduces the setback nonconformities, doesn't even extend them, it actually reduces them. And John had indicated to me that he believes that that can be done as of right. So we have an alternative situation. We have the special permit application. We've provided calculations. We don't think that what we're asking for is substantially more detrimental to the neighborhood. I know that you guys have allowed situations that are much more of an increase in facade and volume and calculations and so forth of as much as 200% in some circumstances. So that's really kind of my quick rundown.
Okay, with that being said, would the board entertain a motion to continue the special permit hearing until Tuesday, June 15th? I'd make such a motion.
Second the motion.
Here's Lee again. Good work. Okay, all in favor? Woody Chitik, aye.
Lee Darcey.
Matt Watkins, aye.
Mike Dickey, aye.
Dave McMorris, aye.
Okay, apologies to everybody that we had such a chock-a-block agenda. We still have a couple of draft decisions to go through. And that last little piece of business about the search committee, but which I've gotten kind of confused here as to which draft decisions are available. Certainly 62 Rust Way is available. We've looked at it. Yes, thanks very much. I appreciate it. So
Thank you.
long time
Right.
waiting around.
Good night.
Good night.
So
Thank
Woody,
you.
I can run through and let you know what drafts I've sent out. 62 Rustway, 137 Nichols, 50. I don't know. We didn't get 51 Gammon's decision. So we're going to we closed that. So we're going to need to file something in 14 days.
On the dock and Gammons Road.
Yes.
Who's got that one?
I think I do, Woody.
Okay, Mike, we'll have to, I mean, speak to me or
apologies.
Jen if you have any questions, please.
Yep.
Yeah,
So-
Michael, you could probably take a look at even the doc decision that I
That's
sent
before
is
tonight. You could use a lot of that.
that's kind of the template that David had initially created and I've adopted to that could be helpful.
Yep. Is it okay if I reach out to you, Matt, for some guidance?
Absolutely.
Yep.
Absolutely.
Okay.
So we have to file within 14 days, the decision.
Which shouldn't be burdensome, Mike. Really, it should be, if it takes you an hour and a half at the most, we're probably okay to draft it.
But it has to be drafted and filed.
Yeah.
And so a decision has to be made this evening as well.
Well, the 14 days, does that take us into the 15th or do we miss it by?
We miss it by a day.
Oh, shit. Okay.
So.
Well, we already voted to close the hearing, right?
Yeah, but do we need a vote with the decision in hand, or could we vote to?
No, you could vote. You can deliberate and then vote, and then Mike Dickey could draft it, send it to me, and I'll send it over to Matt.
Okay,
So do you want to start with 62 Rest Way?
Sure. Yes, but I'm just wondering what else there. The Bodells have continued. The 11 Jerusalem continued for some more information. Obviously, the last two. So we have 61 Elm, which I'm recused on. Did you guys close that?
Yeah,
we did, and there is a decision that Charlie drafted that was circulated.
Okay, but we should vote on that one as well tonight.
Yes. Yep.
Okay, so let's take it at the top, the 62 Rest Way.
Well, we had several hearings on 62 Rest Way, and with each continuance and each hearing, they reduced the size of the proposed addition in the setback. So that if people remember, this house is situated so they are very close in their rear setback, because there's quite a bit of ledge on the property. And initially at the hearing, they were asked if why they didn't.
Yeah, I don't know if you have to explain the whole,
Okay. Well,
hearing, but you basically have approved it. Any conditions, anything that we should
they
do?
still have to go through a large, at the last, they
yeah.
had to go through a large house review. So that was their next
But
stop.
that of course is advisory only, so it's.
Yes.
Right. And they have filed that. May I just interject for one moment to let Cindy and Mara head home?
All right. I thought you were home.
We are, but
Sign off.
Oh, you mean she wants to go to bed? I see. All right. All right. Good night. Thank you.
So I did make the edits that Woody had
Cindy, you're relieved.
suggested.
Okay. No, I was just telling Cindy she was free to go.
I did make the edits that Woody suggested this morning, but the bottom line is that they're increasing the nonconformity by 377 square feet in the setback, and the rear abutter is hundreds of feet away. At this time, it's one house.
This makes a lot of sense to me. Does anybody have a challenge or a concern? Nope.
None.
All right. Well, I would make a motion to approve the decision as drafted.
I'll second that, Woody.
All right, Mike's seconded it. All in favor? Reach it, aye.
Lee Darcey.
Matt Watkins, aye.
Okay,
Michael Dickey, aye.
Dave McMorris, aye.
great. Now we have the a draft decision on the dock on 137 Nichols, the Crumleys. Who drafted that one?
I did.
Oh, that's right. Oh, that's right. That came out this afternoon, right?
Yeah, I had sent it before the last meeting. The only thing I updated this afternoon was just, that we had continued the last hearing. So pretty straightforward dock decision. The only thing that caught me a little bit with the curveball today was just that issue on the rights associated with that 100-foot wide. The people, I know he focused more on the other person today. The hearing in my notes I had associated with this Mr. Paul versus the gentleman they mentioned today. But nonetheless, the dock decision stands as it is. And I just will determine if I don't know if I put anything in there. I don't actually think that 100-foot wide right-of-way depiction has any bearance on the decision, as long as it's mentioned within the write-up itself. I think we're covered there.
Right, they'll have to file that in, at the Registry of Deeds, I think, to make it legal.
Yeah.
And
yeah, so I think it would just stand. I'll just put something in there that he noted.
Acknowledge that there is such a document, or will be, or something to that effect. Okay, well, I'd make a motion to approve that decision at 137 Nichols. Second, moved and seconded, Woody Chidick, aye.
Lee Darcey.
Matt Watkins, aye.
Dave McMorris, aye.
Okay, the next one is the dock at 51 Gammons, not written, but we will, I would like to make a motion to approve it along the lines of the 137 Nichols Road decision. I didn't see any big impediments here to building the dock. It had many of the same characteristics and features. Would people disagree? Otherwise, I think I'd be comfortable making a motion, which I'm doing right now, to approve a decision to be filed within 14 days on 51 Gammons Road.
Second.
Moved and seconded. All in favor, Woody Chidick, aye.
Lee Darcey.
Matt Watkins, aye.
Mike Dickey, aye.
All right.
Dave McMorris, aye.
Okay, great. And we have Charlie still on mute. The next one is, Dave, I'll let you take this one over, 61 Elm Street.
I wrote it's a pretty straightforward case of extending the house into the, well, the whole house is already in the floodplain. This is extending it further into the floodplain. But there's an exception. It has to be over 300 feet to get it. If it's over 300 feet, then we can't give a permit, a special permit. We can if it's under. This is 31 square feet. The sonotubes and the foundation wall, and so it won't affect the flow of flood if it occurs, and it's similar to the neighbors. So I approved it in the decision. My only question, which was answered today, is whether the some of the building is in the side setback, but it confirmed that it's under 15 feet. So therefore, the side setback is it's within this side setback for a building under 15 feet in height.
All right. Anybody have any questions or comments? All right, I move we accept Charlie's decision as written.
I'll second.
All in favor?
Charlie Higginson, aye.
Lee Darst, aye.
Dave McMorris, aye.
Matt Watkins, aye.
Michael Dickey, aye.
Unanimous. And back to Woody.
You're on mute, Woody.
Oh, sorry. And the last little piece is, as I mentioned in an email, the select board is going to be conducting interviews with 5 law firms, 1 or 2 of whom have represented us already, and I think there were at least 3 new ones. So they don't have time, obviously, or bandwidth to have 25 people come in and ask pertinent questions. They did ask me to find out from the board, this board, what particular questions you might like them to ask and pursue. I came up with 2, basically, that had to do with land use. Well, you all have seen it. Land use experience, litigation, have they had appeals, denials, remands? How successful have they been? And then the other piece was, and who does your litigation work? Pretty typically, I think if it's a full service firm, they would have litigators on staff. Otherwise, I believe they would probably farm that out to an expert. But I'm only, my predicate here is that there are, I think, anywhere from 2 to 6 situations where developments will probably end up in front of this board in some way, shape, or form, all having to do with lack of legal frontage, most likely lack of buildability. But it's pretty hard to anticipate that. But I think we're going to need good land use legal counsel. Somebody who knows more than me. Well, what were your additions, if any?
I had one.
Okay.
What is their practice regarding consulting the boards who are the subject to the litigation before settling the case?
Give us that again. In other words, is there a habit to settle without litigating, or no?
No, it's more. If someone sues over one of our decisions,
yeah,
do they get approval of the selectmen to settle it, or do they talk to somebody on the board first?
Is appealed.
Because the selectmen don't have the particular expertise that we do, and they don't really know if settling something is going to affect how we administer the bylaw. And we do.
Exactly. That's a good one. And is that town policy, or is that their behavior or modus operandi?
Yeah, I'd like to know what their feeling is about it.
Well, why don't we say not just the select board, I would say and/or town manager.
Mm-hmm.
I think most of the select board are fairly, by their own choice, removed, but not so the town manager.
Okay. Yeah, I think that's a good point.
Others of you.
No, I agree with David because I, was really disappointed that we had no idea that that other case had settled 10 months, eight or 9 months earlier.
Sandy Beach, yeah. And if it was more than a friar later, we would have been, how do I say this? BS. We would have been just off the wall. Fortunately, it was it was a minor concession on the part of the Sandy Beach folks, but it's not a bad example to follow. I mean, a bad practice.
Yeah, we were kept in the dark and had no idea. I didn't even go to Sandy Beach last summer because I thought that we still had a lawsuit.
Well, I'm not sure anybody, I mean, this was in a transitional period, but that doesn't excuse it. Mike, what about you? You're a lawyer.
I thought your questions were quite good, Woody. I have to say that, you want to obviously look to see if they have the requisite skill and expertise. And that's evidenced by the fact that they've represented similar clients in similar situations. So, if they have a good bench of folks that have been advising other zoning boards, that would seem to me to be as much as anything the key piece of information that you want to drill down on, frankly.
Yeah, because I think a case in point is that I looked at a case today, this 2004 case that Adam was unfamiliar with. Adam is aware of some amendment, I guess, to Chapter 48, Section 6, which I think would be big news. I hadn't heard of that. So our legal representatives have to be really on top of this stuff. We can't be finding out or shouldn't be finding out about some of these seminal situations during a hearing or whatever.
I agree, and again, I'm not stating anything that isn't kind of blindingly obvious, but if you similar situations arise in different communities, and so if you're representing, if you're doing the work for town A, you're a little bit ahead of the game when it pops up in town B and then in town Cohasset C, so it just seems to me that the broader their client base is, where they're doing this type of advice and counsel, probably the better they're going to be for us too. Just because they'll have seen different things, they'll also be able to presumably provide some, best practices advice in terms of, well, town A did it this way and town B did it, a slightly different way, and here's some pros and cons of the different approaches and that type of thing. So again, not rocket science. I think it's just trying to find a firm that has a client base, a broad client base that offers this kind of advice, because they're just going to have that expertise.
Yeah, and it is not the same as environmental law or whatever. I mean, it's just.
Well, that would be what Concom would be interested in getting.
Right.
Council, right?
Yeah, but the planning board also sort of has been at a bit of a disadvantage from time to time, not getting complete advice or paying attention to it. But I won't go there.
I would think that the type of expertise that would be of interest to the planning board would track pretty closely to the type of expertise that we'd want to have too, you know?
Yeah, I think so. I think you're right. Charlie, do you have any points of addition here that we would like the select board or whoever's on their interview committee?
No, I thought your questions were appropriate and broad and covered the issue.
Okay, well, fingers crossed.
Yeah, and my point was actually mirrored Mike's. The question I'd written down was like, do you proactively provide case law for cases that mirror those that are in front of our board? So in other words, if you just recently worked on one in other areas or could give us some guidance, I think that would be helpful. That, and I guess case law and analysis, because I think like even when I looked at like what this, I know it's on a different scale, but even some of the like this memo from the engineering group that was provided, that just kind of breaks down some guidance in a different fashion though, but for the plan that went to the planning board, like something like that could be helpful. But more so, I think, like to Mike's point, if they're working on a case and
or have seen such a case, and
they could say, hey,
give us a little primer or something.
Here's some bedtime reading for your between now.
A lot of this stuff doesn't have to be. But the problem in the state now, and then we got to cut this off, is that the last time Chapter 40A was really done overhauled, I think, was 1975, and so there we have an enabling legislation that's almost 50 years old. What's happened is that there may be 200 important cases that have been adjudicated since then that really have bearing. I mean, they're appeals court or Supreme Judicial Court kind of cases that aren't found in 40A. And to be up to date on that stuff, I mean, I don't know, I don't subscribe to law journals, but it would be great to have a town council saying, here, you've got a situation coming up on X, and there are 2 or 3 relevant cases that amplify.
Yeah, well, again, the thing you ask is if they provide, newsletter services to their clients, do they provide periodic updates on, matters of interest to their clients? Again, a lot of that comes with being a larger firm that has the resources to be able to, send assign a role to a low-level associate, and a smaller firm is perhaps not going to have the bandwidth to kind of do something like that. But it's certainly a service that I see with the larger firms that I deal with. They'll be sending out updates on matters of interest to me and my my practice.
Yeah, and so with that said, this is, we need and training. I mean, there's a metropolitan area planning commission that does some zoning training, but some of this other stuff, whether you call it training or just updates, I think we could all benefit from being a little smarter. And maybe that time to be smarter is when a situation comes up in a current hearing, so that we're not dealing with generalities, but here's a situation that the zoning board in Glasgow is going to face, and here are 3 relevant cases or situations that you may want to get up to speed. So Jen, you and I will massage that, but I think they're going, I can do this tomorrow morning.
Sure. And just to jump on a couple of things that you just said, it was just the training. I'll send an email out that we've been working with the Citizen Planner Association and are setting up probably 6 to 8 trainings over the next year, covering everything that impacts both planning and zoning, but particularly just overall. And our first one is June 22nd, and that's regarding A&Rs. And that's all on Zoom. So you'll get
And are we
invites.
talking daytime or evening on these?
It's evening 5 to 7.
June 22nd. So get us a schedule out because these.
So yeah, that's our first one. We're negotiating our second one. They have to get us teachers. So but it's a long list. I'll give you an idea of what
Okay,
it is.
great.
I just can't believe it's already June. So it's already snuck up on us. And I also did draft 2 sets of minutes that I emailed out on Friday. And that was
Great.
March.
You mean the March and May?
Yes.
Yes, we got them all.
Yeah. So I was just
Okay,
wondering.
well,
if-
listen, we've gone over, but we may have to, and I'd like your thoughts on this. Facing an agenda as we have tonight, and it's not just the number of entries, but there are 2 or 3 very meaty topics. We may want to think in advance of scheduling an interim. I don't want to make that a habit, but to kind of clear the docket, we may want to start thinking about having an interim meeting when the workload starts to build up like this, so we don't go till 11:30.
Right. And I can definitely identify that this was a case of,
Okay, yeah.
yeah, some of the
So
people
it's a-
piling up.
It's a, kind of it'll be a special thing, but I'd rather anticipate that than find myself at 11:15.
The June 15th meeting, is that at 7 o'clock?
Yes.
Okay.
We could start earlier if you want. Yeah. So are you gonna approve my minutes, or are you gonna make me wait till June 15th?
For God's sakes. I make a motion to approve Jen's last 3 minutes.
That's
Why
two.
don't
That's
you
fine.
pull them
I
in?
got it.
I second
Not
that.
subject to any field changes or
I will read them all again, but
I second that motion.
thank you.
okay. Woody Chitik, aye.
Lee Darcey.
Charles Higginson, aye.
Dave McMorris, aye.
Matt Watkins, aye.
Mike Dickey, aye.
All right, guys.
Thank you very much. And now we just have to vote to adjourn.
I make a motion to adjourn.
Second.
All in favor? Woody Chitik, aye.
Lee Darcey.
Aye.
Thank you very much for being so patient.
Thank
Aye.
you all.
Good night, everybody.
Have a good night.
Good night.
See you in
Good
2
night.
weeks.
See you 2
Bye.
weeks.
Oh, I can't wait.
Yay.